Permit to mention, my lord. May I permit to mention one matter?
Huh?
Testamentary matter,
No.
PLA matter, my lord.
I am not.
Your lordship dispose of the matter, my lord. My lord, probate was granted, my lord. My lord, when the registrar going to issue the, my lord, sign the said probate, my lord, it was found, my lord, testators had two addresses. One mentioned in death certificate, one mentioned in the will. My lord, one address was not mentioned in the body of the petition, so my lord, correction is required, my lord. Your lordship take up any day, my lord.
I am not having determination mentioned before the having the court dispose of matter. How I can take this matter? This court disposed of the matter.
Yes, my lord.
So now what you want?
Only for one correction.
Correction, go to the appropriate court. How this court can do now in the disposal matter? Disposal, how? You tell me. Disposal matter, this court is not having the determination. So at today, how I can pass any order in that matter? Yes.
My lord, may I be permitted to mention the suit, the CSC versus 3-chair suit? My lord, I believe my lord was not sitting on the 10th of April when it was supposed to be taken up. My lord may fix any date. Any date next week, my lord. I'm being led by Mr. Dhruv Ghosh, my lord.
Yes, it is. It's a non-commercial matter, na?
Yes.
It will come on 10th, next Friday, 15th, 25th. It will come on.
My lord, the only prayer is because it's a Friday, there might be a chance of a 3:30.
Maybe
So
it is your risk. Court cannot sit. You will take the adjournment. You will have a bar resolution. Whatever. The person
My
who is
lord,
appearing before this court knows what is the how this court acted on the bar resolution. If you persons wanted the matter is to be heard, in spite of the bar resolution, the court welcomes you.
grateful, my lord.
Commercial division, we mentioned item number 1.
But I appear for the defendant in this.
My lord, I appear on behalf of the plaintiff.
Yes.
If my lord looks at the order of 16th April 2025, on the second page, it says counsel for the plaintiff submits that the result of the first suit is dependent on the result of the second suit, your lordship. The first suit is not dependent on the second suit. The first suit is not dependent on the other suit. If your lordship could kindly correct it to the first suit will have a bearing on the second suit.
My lord, it is the other way around. Your lordship, there were two suits filed. Now the first suit, your lordship, the witness action is going on and the defendant's witness is in the box.
Correct.
In the second suit, it's a more or less similar suit, your lordship, for claim of money.
Correct.
So, my lord, this observation of your lordship, the second suit will be dependent on the outcome of the first suit, result of the first suit.
Okay.
This should be the correction, your lordship.
Your lordship, instead of writing instead of directing is dependent upon, if your lordship could observe that it has a bearing upon the second
Same
suit.
thing. Synonymous.
What?
If your lordship could write the first suit will have a bearing upon the second suit.
But you mention what you mentioned, the court has recorded. So suffering for the plaintiff, so suffering for the defendant, the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submit that by an order, and this court by an order dated 16th April 2025 passed an order as per the submission made by the counsel for the parties. Place the matter out of the list, liberty to mention. But in paragraph 5, this court, in paragraph 5 of the order, this court has recorded that the counsel for the plaintiff submits that the result of the first suit is dependent upon the result of the second suit, but it should be the result of the second suit will bearing the result of the first suit. In
Your lordship, if I may indicate, the result of the first suit will have a bearing on the second suit because the reputation.
You do one thing, you dictate me, go and she will dictate. No correction is required.
Your lordship, I apologize.
Sorry. Leave it up. Next.
Your Lordship, I tender.
Sorry, madam. You are the beginner. Yes, call the list.
Well, this matter is appearing at our instance. This is a commercial suit in which, my lord, I appear for the plaintiff, and the examination in chief of my first witness is over. Well, the learned judge who was taking up the suit at that matter wanted certain documents to be proved. I've already proved it. Well, today a date is to be fixed for cross-examining the plaintiff's witness. Well, the reason why we mentioned of the urgency was my witness has retired. He's on extension. So, my lord, unless his cross-examination at least is completed, any day convenient to my lord if my lord could fix it.
Witness action.
Yes,
Which is the last order?
My lord,
19 March.
March. I have a copy.
Okay. Yeah, it is here. Examination chief, witness cross-examination. For cross-examination.
Yes.
Kindly keep it any another day, my lord. Because under instruction, we have to brief the new council for the cross.
If I will fix the date, then you have to come ready.
Yes.
I will not adjourn the matter. That's why I am asking you.
Any day in the month of May.
So and so appearing for the plaintiff, so and so appearing for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Full stop. The counsel for the plaintiff submit that the case is fixed for witness for cross-examination of plaintiff witness.
Yes, plaintiff's witness.
Cross-examination of the plaintiff witness and prays for fixing a specific date and time so that the witness can appear before this court and cross-examination can be completed. In view of the submission made by the counsel for the plaintiff, let the matter appear. कोई डेट है? मई में. मई चाहिए. नहीं है. 11:30 कोई है? 5th of May 11:30 खाली है. 5th May 11:30.
Very grateful to my lord.
For cross-examination of Peter.
Item number 3.
Huh? No, कोई order नहीं.
My lord, I appear for the plaintiff. On
Yeah.
presentation by order dated 2nd April 2025, the plaint was admitted by Lordship after grant of leave under clause 12 of the letters patent. However, Lordship kindly takes order dated 2nd of April 2025. In the third para, it has been recorded, counsel for the plaintiff submits that the plaintiff is within jurisdiction of this court.
Yeah.
However, Lordship, the actual fact is that the plaintiff was situated within jurisdiction of this court at the time when the cause of action had arisen, that is when the sale of the goods, delivery of the goods had taken place. But thereafter, currently, the plaintiff has shifted its registered office to an address outside the jurisdiction. The relevant pleadings, if Lordship can kindly take, is at paragraph 2 of the plaint. May I read, Lordship? The erstwhile registered office of the plaintiff was situated at 7 Pollock Street, 3rd floor, Kolkata 700001. Within the aforesaid jurisdiction of this honorable court, it is pertinent to state that the plaintiff's goods were sold and delivered by the plaintiff to the defendant from the plaintiff's erstwhile registered office at such and such address within the jurisdiction of this honorable court.
Yes.
The certificate of enlistment is annexed at page 30, Lordship, along with the form IMC 22.
Next, what is the
So
correction?
this is the correction.
This is
And
only.
yes, and one more correction is just that in the order sheet, the name of the plaintiff is spelled as Creative Ply Packs. It would be Creative Polypacks Private Limited. These are the two corrections.
Poly, not ply.
Poly.
So and so appearing for the plaintiff. The matter is listed as to be mentioned. Oh, correction in the order dated 2nd April 2025. Counsel for the plaintiff amended. In the order dated 2nd April 2025, at paragraph 3, this court has recorded that plaintiff is within the jurisdiction of this court, but at the time of when the plaintiff sold and delivered the goods to the defendant, the plaintiff's erstwhile registered office was within the jurisdiction of this court, and subsequently it was shifted to the outside of the jurisdiction of this court. Counsel for the plaintiff further submit that in the cause title, the name of the plaintiff is wrongly recorded as Messrs. Creative Ply Packs Private Limited instead of Messrs. Creative Poly, P-O-L-Y, Poly Packs Private Limited. Consider the submission made by the counsel for the plaintiff in the order dated in paragraph 3 of the order dated 2nd April 2023. The same shall be read as the counsel for the plaintiff submit that the at the time of delivery and sold and delivery of the goods to the defendants, the erstwhile office of the plaintiff was within the jurisdiction of this court. Instead, that the plaintiff is within the jurisdiction of this court. And
Grateful, Lord.
cause title of the plaintiff shall be corrected as Messrs. Creative Poly Packs Private Limited. This order may be incorporated with the order dated 2nd April 2020.
Grateful.
Next.
On the previous occasion, by an order dated 18th March 2025,
Yes.
my lord, by a previous order dated 18th March 2025, my lord had directed the officer in charge, the Trichanur police station, who was appearing on the virtual mode on that day before my lord, that it was directed to execute a warrant against the contemners, and the period was extended by the order, my lord. So, my lord, and the officer was the superintendent of police was directed to appear before this court. So, my lord, we have communicated my lord's order by speed post and by email. My lord, may I file the affidavit, my lord? And also, my lord, the officer in charge was present on that date when the date was fixed.
Report has come. Huh? ये पुराना है. मैं order नहीं है. Where is the service?
Well, service I've just handed over, man. It is we have issued by email, my lord, and this with regard to the speed post, we have also served on 16th, my lord. Kindly take up.
Speed post served? No.
My lord, the service it's not reflected as a complete service, my lord. My lord, will kindly take up the last page, my lord. At page 11 is my email. 16th of April at 2 p.m., my lord, I had issued the email. I believe the person is present. Service stuff.
Delivered, SP Tirupati?
My lord, email received, certainly.
Yes.
Milord, good morning, Milord. I am Ramakrishna, Inspector Milord. Already 2 teams was bought, Milord. Milord, 2 teams went to Chennai, Milord. Chennai and surrounding Ainambakam and Radhika, Milord. My team went to that place, Milord, but technically is not identified, Milord. We will definitely catch the
N3H.
Milord.
The court is warrant regularly criminal question. Passport and N3H.
What is the good name?
Milord, my name is Ramakrishna, Milord.
What is the post?
Circle Inspector, sir, Milord. Inspector East Police, Milord. The Chaudhary, Jairam Chaudhary and all are residing in my limits, Milord. But the house was locked since 2 years, Milord.
Hey, Superintendent of Police, SP Tirupati?
Milord, SP sir is in other meeting, Milord. The Temple City, Milord, landlord problem is there, Milord. That's why I am attending the Honorable Court, my lord.
What is this report? Where is the report of Tirupati, SP Tirupati?
My lord, we are sending, my lord.
By an order dated 18 March, this court has directed to file the report. Where is your report? Where is the report of the officer in charge, Tiruchendur Police Station, Tirupati?
My lord, we are sending, my lord. I met an accident, my lord. That's why just slightly late, my lord.
Okay, you met with an accident. Somebody is you are the officer in charge or you are circle inspector?
My lord, officer in charge of that police, my lord.
You are also the officer in charge.
Yes, my lord. Yes, my lord.
So why you have not submitted the report?
My lord, just I met an accident, my lord. Please kindly.
When you met with an accident?
My lord, 25th, my lord. Last month.
25th.
Yes, my
And
lord.
what about the why the SP has not submitted the report?
My lord, we will submit, my lord. We will detail.
When?
Within 2 days, my lord. 2 days, I will submit, my
Tell
lord.
the SP to submit the report and come in person in the virtual mode. Otherwise, I will issue the warrant against both of you.
My lord, please, my lord.
10-3H. My lord,
Tell by which date you will submit the report.
My lord, 1 week, my lord. 1 week.
So how you will submit the report?
My lord, through online, my lord. Otherwise, we will come to the in person, my lord.
Okay, you send the report through email to my to our registrar or urgent site.
Yes, my lord.
I am fixing the matter on 29th.
Yes, my lord. Yes, my lord.
I'm led by Mr. Gupta, my lord. Will kindly grant me leave.
Submission. My lord, the other, the contempt, the alleged contempt, not the other, the alleged 1, 2, and 4, they are unable to get hold of them. So they will be filing reports, whatever it is. But I was relying on Section 10 of the Passport Act,
10-3.
and specifically 10(3)(h), where
That's why no. That's
if
why
the warrant or summons is not being complied with,
that's why I wanted the let the SP report come.
but whatever it is, they have not been able to get hold of.
Let
Let
the report come. On the basis of the report, then I will take appropriate pass appropriate order. Let the report come.
But the local SP has said that he has not been able to trace. That will
No,
be.
that's why on the last occasion I directed to submit the report. Warrant be executed. If it is not executed, submit the report. What is the reason? Give the reason.
But what I was humbly submitting, subject to my lord's kind consideration, till such time, let him not be permitted to fly outside the country. Because in exercise of powers under Section 10, my lord, if a warrant or a summons is not being complied with by any individual, then his passport can be, my lord, court can direct.
Can inform, no problem. It can be informed.
So, my lord, if your lordship
come,
kindly considers that, my lord,
the
and then.
report come with them one week, with the matter of 1 week.
Very
Yes, madam. What is the
Lordship,
submission?
Lordship would kindly take up my application which is appearing.
What application?
Lordship, application for modification of the order dated 6 January 2025. Lordship. Lordship would kindly take page 30. Directions were given, Lordship. Extension was also given to file opposition. That was not done. Lordship would kindly take page 30.
And not file the opposition. Serve the copy.
Lordship, it was not served.
It is not returnable to that. This application is possibly not.
Application was returnable on 17th of April, Lordship. It was fixed for hearing on
Serving-
17th. On 11th of March, direction was given to file affidavit. Extension was given. Lordship,
What has happened on
11th March
17th?
order, 17th April, it was supposed to appear in the list. It was not there because the matter was fixed today also.
What?
She would take 11th March order.
Correct. 17th April.
But she would take let affidavit in opposition be filed within 2 weeks from date.
Correct.
That time expired long back and I was not served.
So you will file reply or without
Lordship,
reply?
I
You
have
forget
to.
the matter.
I have not seen the opposition contents.
I am fixing next week.
Lordship.
Come on Tuesday. So and so appearing for the plaintiff petitioner. So and so appearing for the alleged contender number 5, 6, 7, and 8. Police stop officer in charge. Tiruchendur Police Station, Tirupati. Appeared in person through virtual mode. SP is not present. The officer in charge, Tirupati Police Station, submit that he has met with an accident and he requires a week time to file report. He further submitted the SP is busy in the SP is busy in the law and order situation in the temple. and as such, he has not appeared in person through virtual mode, and he also prayed for extension of time to file report by the SP also. Considering the submission made by the officer in charge, Tirupati Police Station, time to file reply is extended by 28th of April 2025. Let the matter appear on 29th of April 2025 under the same heading. The counsel for the petitioner has filed affidavit in opposition in connection with GA8. GA1 of 2025 after serving the copy to the land counsel for the alleged content number 1, 5, 6, 7 and 8. Counsel for the alleged container prays for time to file affidavit in reply. Let the reply be filed within a week from date. List the matter on 29th.
Can it be Lordship on 6th or 7th May, Lordship?
List the matter on 7th May. Not 7th May then.
6th May or 7th May?
Only GA1. The other.
Let the matter in connection with GA1 be fixed on 12th May.
Grateful,
No,
Lordship.
13th May.
Grateful, Lordship.
13th.
13th May, Lordship. Grateful, Lordship.
Yeah. Yes.
Lordship, item number 7, I appear on behalf of the plaintiff. Lordship would recollect it is that matter where parties had sought time for settlement, and we are through the settlement, and it is yet to get concluded. Another 1 week's time, and hopefully we will be able to submit before your Lordship adequate documents in satisfaction of that settlement.
Lordship, I appear for the respondent bank, defendant number 1. Lord, the matter has been settled between the parties, and my lord, we have also intimated to the borrowers as well as the plaintiff that the title deed has been returned to them. So, my lord, today, my lord, though interim order is required to be extended, so let them file application for appropriate application for withdrawal of the suit. The suit has been itself, my lord.
Lordship, this is our suit, Lordship. They are one of the respondents, but there are other respondents from whom we had bought the property. And they are the ones who had mortgaged it with the respondent number 1. Lordship, there are certain conditions which needs to be fulfilled between us and the respondent number, the other respondents.
Where is the respondent? Other respondents?
They were appearing, Lordship. If your Lordship sees the last order, your Lordship would see Mr. Barney Ghosh was
Correct.
appearing.
2 to 4.
2 to 4.
Correct.
Lordship, we just require another week. Just 1 more week of extension. And then hopefully we will be able to come and
It happened in the month of March.
That's
the settlement
right,
proposal was done in March.
Time.
Now-
My learned friend, I have no grievance against my learned
And my name can be deleted. I may be released
Just
from the suit.
one more week. Nothing will change in 1 week's time.
Sense suffering for the plaintiff, sense suffering for the defendant number 1. None appears on behalf of the defendant number 2 to 4. Counsel for the plaintiff submit the matter is going to be settled between the parties, and as such he prays for a week time. Counsel for the defendant number 1 has handed over a document dated 20th March 2025 and submit that the plaintiff and the defendant bank have already released the original document deposited by Messrs. Coastal Packages Private Limited. Counsel for the defendant number 1 submitted as the defendant number 1 has already released the deeds, and as such there is no requirement for extension of the interim order. Counsel for the plaintiff submitted it is a matter of 1 week, and within 1 week the matter will be settled between the plaintiff and the defendant number 2 to 4 and prays for a week time. In view of the submission made by the counsel for the plaintiff, for the interest of justice, the case is adjourned. Let the matter appear on 30th April 2025. The interim order granted earlier is extended to 30th April 2025.
My document.
Lord,
I'm
before
appearing.
my learned friend starts giving reply, may I also cite so two more judgments, so that my learned friend can deal with them, and hopefully with that
It will come back to your lordship, the proposition which we are addressing before
this is I'm this is with respect to written statement, whether it can be amended post the 120 days period, whether at all that amendment can be gone into at all or not, whether introducing a counter claim in the written statement would tantamount to changing the nature and character of the written statement, and also to that effect that whether introducing counter claim at this stage after the post 120 days period expiry, whether it can be permissible under Order 8 Rule 1 and Order 5 Rule 1 proviso, both provisos newly introduced by the Commercial Codes Act, whether at all it is applicable or not. Briefly to recapitulate to
may I take the opportunity to recapitulate? It is my application. Whichever way, your lordship.
I'll give my learned friend ample chance to deal with the judgments also, so that he can deal it comprehensively. And if he shows some new judgments, kindly gives me that much chance to distinguish them. I had on the last occasion had placed a list of dates. If your lordship kindly takes paper was given the list of dates.
Yes.
Lordship will find that the suit was filed on 21st of February 2023. On 21st of February 2023, 5th January 2024, the plaint was presented. 19th January 2024, the writ of summons was lodged. 24th,
already mentioned.
Yes. If your lordship kindly sees serial number 4, 24th January 2024, the writ of summons was served upon the defendant. The 30 days expired on 23rd of February 2024, and 90 days period expired on 24th of May 2024. Just prior to that, they filed an application for extension of time to file the written statement, for asking for condonation of delay of 73 days, which was condoned by the order of 10th of June 2024. So during that period also they did not introduce the counter claim, and after that if your lordship kindly sees, finally they preferred this application on 6th of December 2024.
Whether the counterclaim, whether the amendment which they have asked for,
yes,
contains any document?
Not new document, but what they have done is if it would have been new document, it would have been very squarely covered by
That's what I'm telling.
It would have been very squarely
they
covered.
Intend to bring any new document?
No, they introduced a new case of counter claim. I am saying this a new case because in the counter claim, what they have sought for is initially they said that they annexed the chartered accountants certificate, which is predates to 2020. So it was very much within their knowledge. So it was with them. So they did not make any counterclaim at that point of time. I am not going into the merits of the matter. In 2020, that certificate is there. In that certificate, the averment that they have made, if your lordship kindly takes the application once. Your lordship kindly takes page 18 of their application once.
Yes.
Page 18 of their application, it's a continuation of paragraph 14, where they are dealing with paragraphs 27 to 31 of the plaint. To that, they say that the lordship kindly takes 7th line from the top, the defendant. The defendant has audited the loss suffered by the defendant. In this regard, a copy of the report of the chartered accountant such and such, dated such and such, that is 3rd of February 2020, stating that the defendant suffered loss and damages.
Page 17.
Page 18. Starts at page 17. Paragraph 14 starts at page 17, dealing with paragraphs 27 to 31.
You are reading from where?
Paragraph 18. Top after 7 lines from the top. Starting with the sentence starting with the defendant has audited the loss suffered by the defendant. Defendant has audited the loss suffered by the defendant. In this regard, a copy of the report of the chartered accountant, such and such, dated 3rd February 2020. So, the application filed for introducing counterclaim in 6th of December 2024. So, on 3rd of February 2020, stating that the defendant suffered loss and damages to the tune of 1,09,73,340. It is stated that there was no necessity and no obligation on the part of the defendant to make any payment to the plaintiff for any dues as alleged or at all. So it's kind of a setup which they tried to plead at that point of time. The plaintiff preferred an appeal, and thereafter it goes on to say whether the proceedings before the National Company Law Tribunal, what happened to that. This was the only averment so far as the chartered accountant certificate is concerned. Now, if your lordship kindly turns over the page, what they are now trying to do is instead of set off, they are trying to introduce a claim of in fact, setup was also not pleaded by them in the written statement, but nonetheless, now they are trying to introduce a counterclaim from paragraph 16 onwards.
Yes.
The lordship will find they have stated that the principal sum is 1 crore 9 lakhs, and they have calculated interest from 2020 till 31st of March 2024 to the tune of 24 crores and odd. And they have introduced the counterclaim by way of this, trying to introduce this counterclaim by way of this amendment. Now, if your lordship on the last occasion I had placed reliance on Order 8 Rule 1 of the Code of Civil Procedure.
Yes, you already Order 8 Rule 1, Order 8 Rule 6A, and Order 8 Rule 9.
Order 8 Rule 9 and Order 8 Rule 10 proviso. So, Order 8, I will not trouble your lordship by reading the provisions again. Order 8 Rule 1 proviso was newly introduced after the amendment of the Commercial Codes Act. And it states that after the period of 30 days, a further period of 90 days will be allowed, which can be the delay of filing the written statement can be condoned. But the period of the maximum time limit of 120 days is mandatory in nature, and the defendant will forfeit its right to file any written statement. So, today, if pausing here for a moment, if a defendant is allowed to amend the written statement subsequent to the
similar. This is I have shown your lordship that it is the rules governing the plaint which is applicable to counterclaim. So, my lord, kindly have a look at Order 7, Rule 11. Rejection of plaint, your lordship would kindly read the word plaint as counterclaim. The counterclaim, may I say it in this way, the counterclaim shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claimed is undervalued and the plaintiff, kindly read it as the defendant here, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so, when the relief claimed is properly valued, but the plaint, in this case counterclaim, is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so, where the suit appears from the statement made in the, if I may say, counterclaim to be barred by any law, and so on. So, my lord, these are the only rules which stops a counterclaimant from filing a counterclaim which is equal to a plaint, which is equal to a cross suit.
No, see, filing of the counterclaim and after filing of the counterclaim, rejection of the counterclaim is different.
My lord, I am
see 711
doesn't require, 711 doesn't require an application. When I am
telling not.
Yes.
I am not telling that. See, here you have asked for the amendment by way of the counterclaim. You file the written statement, but you file the amendment application
only to introduce
the counterclaim. Correct. So whether now here is only the question whether your amendment is to be allowed or not.
Yes.
If the amendment is allowed, then it amounts to a counterclaim will be, and the written statement shall continue with the counterclaim.
Lord, may I put it in this way?
Correct. No, let's
yes.
Order 7, Rule 11. Then the defendant, then the plaintiff have a right to initiate an application under 711 for rejection of your counterclaim.
Yes.
At this stage, this is, I think so.
No, Millard, may I make this submission, Millard? Even when I am trying to introduce a counterclaim, it is the first hurdle is the court itself.
Correct.
Because I will have to satisfy your lordship that the counterclaim qua plaint is not barred by law. It discloses the cause of action and it fulfills the parameters required for instituting a cross suit. If I have to obtain leave under clause 12, I will have to ask for that leave at the very inception of instituting the counterclaim. If I have to, Millard, in a commercial suit, apply for mediation, I have to do that before I introduce a counterclaim. That is exactly what I have done. Because other than that, I would not have been able to file this cross suit through this plaint, which is, Millard, called as a counterclaim. There is no difference in terminology. What I now, Millard, most humbly submit is that Order 8 Rule 6A has not been amended like the provisions of Order 8 Rule 1, Order 5 Rule 1, Order 8 Rule 10, where the parameters of the Commercial Courts Act has been expressly worded, which is the intent of the legislature. In your lordship's judgment, your lordship has, Millard, given importance to the provision of 6G because it says that the rules applying for the plaintiff would mutatis mutandis. Not much deliberation is required over here as far as that aspect is concerned, because the dispute doesn't say, I am not, or my learned friend is not trying to say that the dispute is with respect to filing of written statement to my counterclaim. Of course, it is 120 days because Order 8 Rule 1 specifies what is the time limit within which the defendant has to file. In this case, within which the plaintiff has to file the written statement. But over here, Millard, Order 8 Rule 6A Sub-Rule 1 gives me a right to file a counterclaim within certain parameters. Now, Millard, your lordship is considering Order 6 Rule 17.
So why you have not filed the counterclaim along with the written statement?
Millard, we didn't file the counterclaim along with the written statement, Millard, maybe for several reasons. One of them most certainly was that the period of mediation.
And second thing, this the report which you relied upon, 28th of that audit report. That audit report.
166.
No, not non-starter. That is 3rd
yes,
February
3rd of February 2020.
Chartered Accountant report. That you relied upon in the written statement.
Yes.
Where is that?
My learned friend has already shown that, Milord. Your Lordship will kindly come to paragraph page 18. That is annexure J. So, Milord, there is no change in the nature and character of my pleading.
Yes.
Now, when your Lordship, Milord, is testing whether I am entitled to file a counter claim, your Lordship will appreciate that I have a right to amend the written statement under Order 6, Rule 17. That has not been amended by the Commercial Courts Act.
Yes.
That has not been amended by the Commercial Courts Act for the only reason that because of any subsequent development, a person may have to approach the court, a defendant may have to approach the court, even in commercial suit, to amend the plaint or the written statement.
Okay.
So, Milord, there cannot be any embargo with respect to the aspect of right to amend. But of course, if it is done before trial, it is a matter of right. If it is after trial, then one has to explain and give reasons why he didn't do it before trial commenced. So, Milord, I have a right to amend my written statement because trial hasn't begun. What I only intend to introduce is the counterclaim, and that has to be looked into as a plaint. In these aspects, Milord, I had on the last occasion, Milord, handed up a judgment. May I please rely on
Which
that,
one?
Milord? That is, Milord, Ashok Kumar Kalra versus Wing Commander Surendra Agnihotri.
Yes.
Milord, may I kindly invite your... Milord, this is a judgment, 3 judges bench of the Honorable Supreme Court, Milord, where of course, the issue was not with respect to commercial disputes. I am saying, Milord, with deepest respect, that even this aspect doesn't require deliberation from Commercial Court Act angle. Because there is no amendment to Order 8 Rule 6A or Order 8 Rule 6A Sub Rule 4. There is no amendment to that. So there is no change of the law as far as filing of counterclaim is concerned. Milord, kindly have a look at paragraph 5. This was the submission. Paragraph 4 is the submission of the person who filed the appeal. This is the submission on behalf of the respondent. This is what the court was looking into. Paragraph 5 at page 402.
Yes.
On the other hand, the learned senior counsel for the respondent submitted that the language of the statute and the scheme of the order indicates that the counterclaim has to be a part of the written statement. This is argued before your Lordship even now. The learned senior counsel strengthened the above submission by relying on the statutory requirement that the cause of action relating to a counterclaim must arise before the filing of the written statement, and submitted that the counterclaim must therefore form a part of the written statement. The learned senior counsel also relied on the language of Order 8 Rule 6, which requires a defendant's claim to set off to be a part of the written statement, to suggest that the same rules should also apply to filing of counterclaim, keeping in mind the placement of the provision relating to counterclaim in Order 8 Rule 6A CPC. Now, Milord, kindly comes to 6.1, 6.2. These were the issues framed before the court. Whether Order 8 Rule 6A CPC mandates an embargo on filing the counterclaim after filing the written statement. If the answer to the aforesaid question is in the negative, then what are the restrictions on filing counterclaim after filing of written statement? Now, Milord, kindly have a look at paragraph 12. Because I say, Milord, with utmost humility, that there has not been any amendment to Order 8 Rule 6A. So, Milord, it really doesn't matter whether it is a commercial dispute or a non-commercial dispute. It is only what that your Lordship will have to see whether I have a right to file my counterclaim or not, and what are the parameters. This judgment deals with that in great detail. Milord, paragraph 12. The counterclaim has been treated as a plaint. I am relying on this, Milord. Has to be treated as a plaint and governed by the rules applicable to plaints. Order 8 Rule 6G says that the rules relating to a written statement by a defendant shall apply to a written statement filed in answer to a counterclaim. Your Lordship has held this. As per Rule 8, any ground of defense which has arisen after the institution of the suit or the presentation of written statement claiming a set-off or counterclaim may be raised by the defendant or plaintiff as the case may be in his written statement. So, Miller, they have a right. When it kindly comes to the three parameters which the court sets up, the last line of paragraph 12. At the cost of repetition, we may note the conditions for filing a counterclaim under Order 8, Rule 6A. So these are the conditions. First, counterclaim can be for a claim of damages or otherwise. Counterclaim should relate to the cause of action which may accrue before or even filing the suit. If the cause of action in the counterclaim relates to one accrued after filing of the suit, it should be one accruing before filing of the written statement or the time given for the same. My case, Millard, is my cause of action had accrued in February 2020. Suit is filed in 2023. I only need to now show your lordship that my counterclaim is not hit by the provisions of Order 7, Rule 11 on the face of it, because your lordship can reject it even on the face of it. Now, Millard, kindly come to paragraph 17. I shall show a few more paragraphs, but I intend to complete today. Millard.
You already record.
No, Millard, paragraph 17.
Take a note of it.
This last 4 line I want
paragraph
to
17.
I want
as
to read
counterclaim
once
is
again.
to be a plaint.
Yes, as a counterclaim is treated to be a plaint, generally it needs to first of all be compliant with the limitation provided under the Limitation Act 1963, as the time-barred suits cannot be entertained under the guise of counterclaim just because of the fact that the cause of action arose as per the parameters of Order 8, Rule 6. They do not run a case that my counterclaim is time-barred on the face. Their case is that it should have been filed along with the written statement because of Order 8.
They have not taken the plea of the limitation.
No, but I must say this, my lord, that in the affidavit in opposition, they have worded it in a manner which may indicate in this fashion. That's why I had handed up before your lordship the last order passed by the Honorable Supreme Court during the COVID exigency. And I had made my submission with respect to that also.
Okay.
But since at the time of submissions, my lord, this is the case which, according to me, has been brought up. My lord, kindly have a look at paragraph 18 once, my lord. As discussed by us in the preceding paragraphs, the whole purpose of the procedural law is to ensure that the legal process is made more effective in the process of delivering substantial justice. Particularly, the purpose of introducing Rule 6A in Order 8 CPC is to avoid multiplicity of proceedings by driving the parties to file separate suit and see that the dispute between the parties is decided finally. If the provision is interpreted in such a way to allow delayed filing of counterclaim, the provision itself becomes redundant and the purpose for which the amendment is made will be defeated, and ultimately it leads to flagrant miscarriage of justice. At the same time, there cannot be a rigid and hyper-technical approach that the provision stipulates that the counterclaim has to be filed along with the written statement, and beyond that, the court has no power. The courts, taking into consideration the reasons stated in support of the counterclaim, should adopt a balanced approach, keeping in mind the object behind the amendment and to subserve the ends of justice. There cannot be any hard and fast rule as to say that is in a particular time the counterclaim has to be filed. By curtailing the discretion conferred on the courts, the trial court has to exercise the discretion judiciously and come to a definite conclusion that by allowing the counterclaim, no prejudice is caused to the opposite party. Process is not unduly delayed, and the same is in the best interest of justice, and as per the object sought to be achieved through the amendment. But however, we are of the considered opinion that the defendant cannot be permitted to file counterclaim after issues are framed and after the suit has proceeded substantially. It would defeat the cause of justice and be detrimental to the principle of speedy justice as enshrined in the objects and reasons for the particular amendment of CPC. Now, Millard, paragraph 21 sums up the categories. I am not, Millard, reading them aloud because none of these categories are, Millard, objected to by the plaintiff.
Yes.
However, Millard, I must indicate that there are 10 such categories which the Honorable Supreme Court, 2 judges, this is a portion, my lord, which is dealing with 2 judges, because the 3rd judge has given an additional view. So, my lord, paragraph 21 gives this reasons. Now, my lord, kindly comes to page 410, which is, my lord, the portion of the judgment of the Honorable 3rd Judge. It begins from 408. I want to place reliance, my lord. Paragraph 29, which is at page 410.
Yes.
Further, under Rule 6A, Subrule 2, a counterclaim is stated to have the same effect as the plaint in a cross suit, so as to enable the court to pronounce a final judgment on the original claim as well as the counterclaim in the same suit itself. Thus, it is evident that Rule 6A has been carefully designed to meet the purpose of avoiding multiplicity of proceedings. It is clear that Rule 6A1 only places a limitation on the time within which the cause of action for a counterclaim must arise. Besides this limitation, there is no explicit guidance in Rule 6A as to the time within which the counterclaim itself must be filed. In this respect, Rule 6A, Subrule 4 provides that a counterclaim is governed by the rules applicable to plaints. It is well established that a plaint must be presented within the period prescribed under the Limitation Act 1963. For counterclaims as well, the period within which they must be filed can be inferred from Section 3(2)(b), Subrule 2. And it reads, my lord, for the purpose of this Act, any claim by way of a set-off or counterclaim shall be treated as a separate suit and shall be deemed to have been instituted in case of a counterclaim on the date which the counterclaim is made in court. This provision mandates that in order to determine the limitation period applicable to a counterclaim, it must be treated as a separate suit which is deemed to have been instituted on the date on which it is made in the court. Thus, evidently, in connoissance with the provisions of Order 8, Rule 6A, Subrule 4, the Limitation Act also treats the counterclaim like a plaint. This means that much like a plaint, the limitation for filing a counterclaim also depends on the nature of the claim and is accordingly governed by the period of limitation stipulated in the Limitation Act. From the foregoing discussion, it is clear that a counterclaim can be filed in 2 conditions if they are met. First, its cause of action complies with Order 8, Rule 6A1. And second, it is filed within the period specified under the Limitation Act. Clearly, by itself, Rule 6A does not specifically require that a counterclaim has to be filed along with the written statement. In the absence of a particular mandate under this rule, it is necessary to look to other provisions of the CPC to determine whether a counterclaim can be filed after a written statement. Now, my lord, after this, the court takes into consideration several provisions, and at paragraph 34, there is the summation. May I please, my lord? In addition to this, it is also possible to introduce a belated counterclaim by way of an amendment, I am on this, my lord, to the original written statement under Order 6, Rule 17 CPC. However, as in the case with Order 8, Rule 9, the filing of such a counterclaim through an amended written statement is subject to the leave of the court and not accorded to defendant as a matter of right. And I also rely, my lord, on the observation of the Honorable Supreme Court at paragraph 35, which quotes the judgment reiterating the same. And you know, the last 3 lines, I fully agree with this proposition.
Yes.
You know, kindly comes to the last 3 lines of the
Yes.
portion in italics. Thirdly, a counterclaim may be filed. It's in the italics portion. Thirdly, a counterclaim may be filed by way of a subsequent pleading under Rule 9. In the latter 2 cases, the counterclaim, though referable to Rule 6A, cannot be brought on record as of right, but shall be governed by the discretion vesting in the court, either under Rule 6 or either under Order 6, Rule 17 CPC, if sought to be introduced by way of amendment, or subject to exercise of discretion conferred on the court under Order 8, Rule 9 CPC, if sought to be placed on record by way of subsequent pleadings. emphasis supplied. I fully agree with this proposition and affirm on the basis of the foregoing discussion that the court has the discretion to allow a counterclaim to be filed after the written statement in exercise of power under Order 8 Rule 9 and Order 6 Rule 17. Now, Millard, kindly have a look at paragraph 38. This paragraph 38 deals with the aspect of Order 6 Rule 17 directly. A conjoint and harmonious reading of Rules 6A, 9 and 10 of Order 8 as well as Order 6 Rule 17 CPC thus reveals that the court is vested with the discretion to allow the filing of a counterclaim even after the filing of the written statement, as long as the same is within the limitation period under the Limitation Act 1963. In this regard, I agree with the proposition laid down in the decisions given below. Now, there are few decisions here. 41, it concurs with the two decisions in 39 and 40. Millard, I'm not reiterating it, but it is important, Millard. So, Millard, ultimately, in this particular judgment of the Honorable Supreme Court, the set of two judges jointly, and Millard, the third Honorable Judge, has given the clear view that Order 8 Rule 6A 1, which talks about counterclaim, it says that counterclaim has to be treated like a cross suit, and it has to be treated as a cross suit, and the counterclaim is equivalent to that of a plaint. So, Millard, I only know if that is so, Millard, then the provisions of Order 8 Rule 1, which only deals with written statement, it doesn't apply to counterclaims. Order 6 Rule 17, as far as that is concerned, I am before your Lordship much before the trial has commenced, and we have taken inspection of their documents. The plaintiff has not approached us to take inspection of our documents. So, Millard, we are
inspection is taken by both.
Both have be
taken
that as it may,
inspection. It was fixed for issues.
One would agree that trial has not commenced. My learned senior colleague has already said that. So, Millard, this is the aspect with respect to Order 8 Rule 6A. As far as, Millard, the counterclaim is concerned, just, Millard, have a look at, if Lordship kindly takes a look at, Millard, pages 19 and 20 of mine. This is, Millard, dealing with, the Lordship has taken a note, but still, Millard, at the time of concluding, I would, Millard, want your Lordship to have a look at it once again. Millard, page 19 and 20 are the only amendments which I have sought for. This squarely deals with, Millard, institution of the counterclaim. It doesn't talk about it does not make any additional statement which affects the nature and character of the suit. It arises out of the same series of transactions, which is, Millard, complained of in the plaint and defended in the written statement. So, Millard, I have not brought a new case. It talks about, Millard, introduction only of the counterclaim. So, in my most humble submission, Millard, this counterclaim should be allowed. As far as, Millard, your Lordship's judgment is concerned, Millard, with deepest respect, Millard, this was dealing with a different issue. That is, what should be the time limit for the plaintiff to file written statement to the contract. Written statement is not equivalent to that of counterclaim. This is the distinguishing factor. And to that respect, Millard, even the Honorable Division Bench's judgment, the issue which was before the Honorable Division Bench was that. With respect to, Millard, page 14, the guidelines which has been given, Millard, also deal with filing of written statement to the counterclaim. It does not talk about any procedure for filing of counterclaim. It is only dealing with filing of written statement to counterclaim. These are, Millard, my most humble.
Okay. Millard, so far as, Millard, the last judgment, Millard, which had, Millard, been relied upon by my learned friend for such a long time, Millard, this is, Millard, in my respectful submission, will not be applicable in the facts of this case, because, Millard, the judgment, Millard, squarely, Millard, deals with, Millard, the unamended provisions of, Millard, the Code of Civil Procedure. Millard, this has not taken into account, Millard, the provisions of, Millard, the Commercial Courts Act and my lord, the amendments, my lord, thereafter, my lord, taken in, my lord, the Code of Civil Procedure. So, my lord, squarely, my lord, this is, my lord, in respect of, my lord, now, my lord, there are several judgments of the Honorable Supreme Court, my lord, which says, my lord, the written statement, the mandatory period so far as a non-commercial suit is concerned is definitely, my lord, not mandatory so far as, my lord, filing of written statement is concerned. So, my lord, this is automatically like that. One of those judgments which says that these stringent provisions of the Commercial Codes Act will not be applicable. So, my lord, this, my lord, judgment, my lord, I have not, my lord, dealt with it separately because, my lord, is clearly not applicable. It's not a commercial suit, has not even, my lord, once, my lord, said about, my lord, any of the provisions of the Commercial Codes Act. My lord, it has not taken into consideration, my lord, Order 8 Rule 1 proviso, or Order 8 Rule 1, Order 5 Rule 1 proviso, or Order 8 Rule 10 proviso. None of, my lord, the provisions have been considered over here. It is a judgment in independent respect which says that a counterclaim can be allowed and can be treated as a plaint once it is filed, and my lord, the stipulations so far as, my lord, filing of counterclaim is concerned, or by bringing in a counterclaim by way of amendment is concerned. Okay, it does not deal with, my lord, none of, my lord, the provisions of the Commercial Codes Act.
Lord, I had missed the SCG contracts judgment, which was relied. I would have relied on it myself, only to say, Millard, that the Honorable Supreme Court, while dealing with Order 8 Rule 1, Order 5 Rule 1, and Order 8 Rule 10, has, Millard, given impetus to the legislative intent of introducing a consequence of default. The consequence of not filing written statement within 120 days is forfeiture. But the consequence, but there is no such consequence embedded in Order 8 Rule 6A. That is the distinguishing factor.
Okay.
My humble suggestion.
Well, will it be your lordship's pleasure that notes be exchanged between the parties, or your lordship? If you intend to give the notes to you, otherwise I will deliver the this no problem.
Have to draft it. We'll again have to draft it then.
Okay, but we can. We'll assist your lordship.
Yes. Within Millard, your lordship will give us some time, Millard, 7 days.
So and so suffering for the plaintiff, so and so suffering for the defendant. Hearing in connection with GA2, GA-Com 2 of 2024 is concluded. Parties are directed to file their written notes of argument within a week. Let the matter appear on let the matter appear on 30th April under the heading to be mentioned for filing written notes.
I'm grateful.
I'm deeply obliged
by both the parties.
Lord, I appear for the plaintiff, my lord.
And for the defendants, but
My affidavit of service, my lord. This is my application for injunction by an order dated 24th of March 2025. Your lordship has been pleased to, my lord, grant an ad interim injunction, my lord. And after that, my lord, I have served copy and, my lord, I have filed the affidavit of.
So you are appearing for defendant?
yes, I was
for the affidavit.
No, my lord. This is coming up for the first time, my lord. In addition thereto, my lord, we intend to move an application under Section 10, my lord. It has already been affirmed. It will appear in lordship's list, my lord. It has already been affirmed, my lord. It will appear in lordship's list, my lord. My lord, there is a prior suit, my lord, which we have instituted against them, challenging the same agreement, my lord, whose specific performance they seek, my lord. And it's a prior suit filed before the City Civil Court, my lord. And we say that since the issues of that suit is larger than the issues that has been raked up by them over in this suit, my lord, so this should be stayed. And that would be our submission, my lord. We are opposing this extension of that is the suit for cancellation of that agreement for sale, my lord. This is for specific performance of the same agreement, my lord. So we are opposing this extension, my lord, on that ground, my lord. We have not used any affidavit, but this is for the first time that the matter has appeared.
Whereas, my lord, the suit probably, my lord, the no summons has been served with regard to that suit. Lord, and my lord, subject to correction, my lord, Section 10 would bar a trial of the suit, my lord. The interlocutory, my lord, application can.
Now let the application come up, my lord. Lordship deals it as and when the application comes up. But as on date, my lord, we are opposing the extension of this interim order, my lord. Then we leave it to lordship. No affidavits have yet been filed.
So and so suffering for the plaintiff, so and so suffering for the defendant. Where is your affidavit of service?
That's fine.
Affidavit of service filed by the plaintiff be kept in the record. Counsel for the defendant submitted. The defendant has already affirmed an application. GA number is assigned. My lord, it has been affirmed already. Has already affirmed an application under section 10 of the Code of Civil Procedure, praying for a stay of the present suit, as the defendant had already initiated prior suit of the same cause of action before the London Court of City
Civil Court at
City Civil Court at Calcutta. Full stop. Counsel for the plaintiff submitted, as the defendant has counsel for the defendant submitted, as the defendant has initiated, as is going to counsel for the defendant submitted, the defendant has taken a plea that the proceeding of the present suit is to be stayed, and as such he has opposed for extension of the interim order, which is going to be expired today. Full stop. Concerning the submission made by the counsel for the plaintiff, this court find that though the defendant is going to file an application under section 10 of the Code of Civil Procedure, but that is not on record, and when the application will be placed before this court, this court will consider the same on merit. It is found that by an order dated 24th of March 2025, this court has passed an interim order which is going to be expired today. Now the defendant has entered appearance. You will file affidavit. The counsel for the defendant also prayed for time to file affidavit in opposition. Let affidavit in opposition be filed within
4 weeks.
4 weeks. The reply, if any, there to be filed within 2 weeks thereafter. Full stop. The interim order granted earlier is extended till 4 weeks, 2 weeks. Till 10th of June 2025 or until further order, whichever is earlier. It is made clear that if the defendant will file an application under section 10 of the CPC, the same will be taken up for hearing on merit.
Great.
My lord, I appear for the plaintiff in this matter. My lord, there are 3 applications today in your
Yes, that. What's the judgment you are relying on?
My lord, what I'm submitting, my lord, I don't want to waste your lordship's time, my lord, on this. My lord, only on two aspects, my lord. My lord, the application drawn by me, my lord. Uh, Kindly consider why I have sought, my lord. I could have sought as party, third party as defendant, but my lord, the reason, my lord, why I sought him as a plaintiff, because my lord, the defendant, if I make him defendant, obviously he will support the plaintiff. Now,
and if you made the plaintiff,
yes,
how you will proceed with that? Because it is not the application of the third party. It is the application of the defendant. And you want the third party should be a plaintiff.
Yes.
One of the plaintiff.
Yes.
If suppose
I understand that.
If suppose this court pass an order allowing your prayer by adding the as a plaintiff number 2, what would be the effect? If he will not come.
My lord, in response to that, my lord, I can only say, so for the limited knowledge I have, my lord, they are group of companies, they can be represented by the plaintiff, and they share common interests.
Unless he has approached, that's what I'm telling.
Yes.
That's why I'm telling. Yes. If you have been added,
yes.
If you have on your application this court is added, yes, and he will be added, he cannot serve the copy to the added plaintiff. The added plaintiff has to come his own.
But my difficulty, if I make him defendant, that then it will also not serve the purpose, because obviously, my lord, they have not.
You are missing the bus. You are missing the bus.
Absolutely.
First bus you have missed. Second bus you are going to miss.
My lord,
consult some senior. Consult some senior. The big matters not to. It is not a joke.
The difficulty is my client is not in a position to afford fees.
Then he has to be a.
I suggested him.
Then
so far, whatever limited knowledge I have, I have applied everything. I studied several judgments yesterday, but those are either at the instance of third party who wanted to.
Your studies as a misguided missile. You have not studied which point you have to study.
But I am learning, my lord. Maybe my learning.
Yes, Mr. Das, what can
but I can't.
My lord, I'm only one prayer, my lord, based on the principle laid down in those two judgments. Your lordship, only one prayer I will make. Since the materials are recorded before your lordship, my lord, under the order 1 rule 10, my lord, has a judicial discretion, and this judicial discretion can be applied based on records, and suo motu can apply by the court, and prayers can be these since these are procedural law, prayers can be molded. Your lordship can always
in the civil suit. In the civil suit. The civil suit.
Addition of party.
Addition of, that's what see. The court is not telling that the addition of party is not permissible. It is permissible. Yes. Correct. It is permissible. But only here the question in the present case, which you have made out a case, if this court, suppose this court allows also your application, what would be the effect? What would be the effect? If it added the defendant, naturally the plaintiff has to take add amendment and issue notice, and all these things will come. If he has been added as a plaintiff, so who will take steps? If the plaintiff, okay, the present plaintiff will take steps and he will amend it. He will amend. But where is the affidavit of the added plaintiff? Who will affirm? And you have not served this notice to the party concerned to whom you wanted to make a party to as a plaintiff. You have not made a party, sent a notice. You can't, because he is not a party to the suit.
My lord, that is why, my lord, I made a alternative submissions if your lordship feels.
For what?
It could be added as a defendant at least.
But how it can be?
Yes, prayer is
The
there.
total pleading is totally different. Addition of parties also to consonants of the pleadings.
But even then,
Milord, there is one instance, Milord. Milord, may I just refer the two paragraphs from both these two judgments, Milord?
Yes.
Your
Which
lordship,
paragraph?
আমি তোমাকে দিয়ে দিচ্ছি এটা আর আমার শেষ করে দিতে হবে হ্যাঁ ঠিক আছে yes 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 my lord kindly take my lord 1994 SCC online Allahabad 304 yes my lord my lord kindly come to paragraph 26. My lord, I am reading from the middle. Kindly see there is a paragraph starts such a gross injustice. My lord, at the middle.
At the middle?
Yes, my lord, paragraph 26.
Paragraph 26, yes.
Yes. My lord, 18th line from the bottom below. Such a gross injustice has been done by the learned additional judge could not have been imagined. He mechanically rejected the application for Motilal Jain, who prayed for being treated as a party. The theory of dominus litis deciding the real matter in dispute. A person is necessary party, the court can order such person to be impleted. Merely because the plaintiff does not choose to implete a person is not sufficient for rejection of an application for being impleted. The equally extensive, even without an application to be impleted as a party, the court may at any stage of the proceeding order that the name of any party who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessarily in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added. So the learned additional civil judge was totally wrong in believing that so and so is implement was not necessary for proper adjudication of the case. Although at page 4 of the judgment, while dealing with the point of dominus litis, that the court may consider whether the joining of a person is essential or not, but still he has proceeded to delude himself that even without the implement of Sri so-and-so, an effective decree could be passed. It amounts to play Hamlet without the Prince of Denmark. Here, my lord, may I just indicate this application was taken out by the third party.
Correct.
Yes. The application was taken out by the
third party or plaintiff for the court so moto find that he is a necessary party can be there is no doubt on that, but here your application is something else unknown. You can file an application added defendant, but you cannot file up if the plaintiff has not made a sister or whatever, it is okay, but here it is not the case. How the you satisfy me this satisfy this court if your application is allowed. How the plaintiff number 2 will act in accordance if he has been added?
Plaintiff number 2.
If it's added today, so how he will act?
His interest will merge with the plaintiff.
How if he come? No, I am not interested with the matter. I am not concerned with that. Whatever his claim is with you, he is not concerned with them. Then what he will do? Plaintiff should be the plaintiff should file a suit claiming some relief. Okay, defendant can be. Okay, relief cannot be, but you are the necessary party. The plaintiff is filing the suit, not mere necessary party. plaintiff, if filing the suit, plaintiff should disclose the cause of action and the relief sought for. If this court, that's why I'm again and again asking if this court allow your application and the plaintiff, the Netherlands and this plaintiff group is added. Correct. And the plaintiff will issue the notice amendment. So what purpose should be served? Unless his affidavit is on record, who will affirm the affidavit of the plaintiff number 2? The court cannot say, now you come and join. Come as a plaintiff. Yes, take what your decision. Want order or you will withdraw this? You have some other recourse, but you are not understanding.
Lord, let me take instruction, my lord.
What instruction?
How long, my lord?
That's why how long? This is the 4th day.
Yes.
Earlier court given in liberty, you file an application. That application is Subhanallah.
Section 8 argued for 3 days, then Section 3's application.
When I was drawing the petition, my lord, the first thing struck me, my lord, whether to add the third party as plaintiff or defendant. I thought if I add him as a
It
defendant,
fell from your lordship. Lordship had advised him.
if I add him as a defendant, he will obviously not come.
Come or not come, that is different.
That's different.
Come or not come.
But really, I did not make the research I did in last few days, my lord. That time I did not.
What do you want?
If your lordship sees by GA3, even after the suit was instituted, the defendant has acknowledged in favor of the plaintiff, not in favor of Netherlands. See his email, one I have annexed. Post-suit admission. After all this, the defendant, how far the defendant can be entertained? That's
not my only difficulty, my lord. Those are, of course, because the WSI have not filed. My grievance, my client's grievance is the
you have not filed the WS, okay, but yes, you filed the affidavit in opposition of
yes, I have in my DA.
13 or GM?
No, this is a judgment
affidavit.
Order
Yes,
12
affidavit in
You have filed the affidavit. You argue on that.
Yes.
That can be done.
And in my DA,
Because you not file the written statement, this will not create any further leave to you file the written statement. Even the other party being added, you will not get an opportunity.
Yes,
your opportunity has gone.
That is the difficulty.
So,
and since I have filed Section 8 for referring, so I did not file the WS.
It's always without prejudice.
See, Section 8 it's okay, but the Section 8 has to decide by this court, and Section 8 again the same question will fall.
Yes.
Again, the same question will fall. How the Section 8 is applicable to him if the parent...
no, 8 read with 45.
Huh?
8 read with 45.
Maybe 45. What the 45 say?
45 is in case of an international arbitration where the party seeking to get an appointment.
That I'm asking
has
what
to
is the
approach
45 say?
And it is also extended to third party. Any. Yes.
That is also. Yes. If you go by that also, that is the main, who is the main contractor?
No, I'm not claiming under the contract at all.
No, yes,
under the invoices.
Obviously, because if my lender friend disclose agreement, then he has to make
payment. If you
party to the
acknowledge,
parent.
Can I dispose of this?
My lord, I leave it to your lordship. If your lordship gives one more opportunity,
when you will come on that day, I will dispose of all the application. In this application, 8 application, 12. This all 3 applications will dispose of simultaneously. Tell me when you will ready.
My lord, last week of April, any day. Last week of April, any day. Subject to your lordships.
Census suffering for the plaintiff, census suffering for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 29th April 2025 for hearing of all connected applications.
Grateful.
Grateful. Next.
Already in item number 13, there are two GA. GA number 5 and GA number 6.
Yes.
This is my application. I am not a party to the suit, my lord. Mr. Bose is. Mr. Bose, my lord.
My lord, the application to implead. No, dore chole এসেছি। Impleadment application. I seek to be added as a defendant in the suit. That another connected suit is there where I have filed a suit against the two parties here, which is the plaintiff and the defendant number one. Because one of our principal contention is there's a collusion between the plaintiff and the defendant number one in this suit for which I want to be impleaded. But if your lordship, it will come back to your lordship. This is a property which was given on lease by the plaintiff to the sole defendant right now with a right to construct and sublet. Constructed, old building demolished, new building constructed, entirety of the property sublet. I am the lessee of the unexpired period of the leasehold interest, which is 99 years.
I'll file an affidavit for his file an affidavit.
Not filed.
No, this moves
Coming for the first time. Coming for the first time.
With GA3? GA3?
No, GA3 is my application. That is the parent injunction
GA5.
application.
GA5.
GA5 आया?
Oh, my lord, let it appear in the list on 28th. My lord, will let us not do it
GA5
today.
is not listed. Fine.
List, it is listed.
Listed. আমার master summons take out করেছে, master summons says so.
হয়ে গেছে।
Have you received?
Yes, yesterday we have received.
Yesterday.
I'm sure Mr. Sen will not take that as a ground.
Of what?
No. You have to wait on the 28th. So they can file their affidavit to GA5.
And the interim order which is existing in GA3, that will be extended.
When is the last date?
It will be extended on April 28.
Is there any interim order?
Yes, in my suit. My suit there was. From the beginning there was.
I have one additional here. I am the defendant number one in this suit.
দাঁড়া আগে অর্ডারটা দেখিয়ে দিই kindly have a look. March 21 is the last order. March 21
March order high.
Interim order granted earlier is extended till 28th April. আছে order?
So and so suffering for the plaintiff, so and so suffering for the defendants. Dependents. Who is for the defendant?
There's a sole defendant, man, one defendant.
For the defendant. And you are for the intervener.
21.
I am the applicant in GA5. I seek to be impleaded as a defendant in the suit.
And so and so suffering for the applicant who has filed an application being GA5 of 2025 for impleading the applicant as defendant in the suit. Counsel for the plaintiff prays for time to file affidavit in opposition in connection with GA number 5 of 2025. Let affidavit in opposition filed by
GA number
5 and 6. There are two applications by two parties. I got two. 5 and 6. Applicant
by 2 weeks, my lord.
Applicants have filed an application for impleading them as defendants.
ওদের এত কাজ তোরা আর কি করবি কখন আমাকে দিয়ে একটু লিখে দেবো
impleading them as the defendants.
or you have to say that civil court of another court, not this court. Now, Millard, I have relied on few judgments before your lordship. Millard, I'll just quickly go through the judgments once again. That, Millard, the referral court, Millard, if I am not wrong, I have relied on two judgments of Justice Sanjeev Banerjee and one judgment, unreported judgment of Justice Shahidullah Munshi. The referral court must be specific and not vague. Millard, two judgments of Justice Banerjee has specifically said that if the referral court is not specific, Millard, there cannot be any reference. Why I say to this? Millard, this litigation, anywhere we go, it has to be a commercial, anywhere. Nowhere I can file this Millard litigation in a non-commercial jurisdiction. Now, Millard, the NIT, though Millard have challenged that, Millard will recollect that Millard in the invoice, it is written Millard STA cases in my invoices, and their NIT says LT cases, number one. Number two, in the invoice, there is a specific number of the Millard NIT. But Millard, in this, there is no number. Their claim is that my signature is appearing at the bottom. Millard, I am still working with them. I am working with them for decades. So I may have signed several documents. So Millard, my lord will have to look into whether this NIT is the relevant NIT in this present case or not. Millard, my reply to that was, Millard, that this cannot be gone into at this stage. And my lord also in 30th July order had Millard specifically held that these things has to be decided in trial. And that was a Millard specific finding of your lordship. Millard, my contention was that to that there has been no challenge as on date, neither recalling, no appeal. So Millard, though my lord seemed to be disagreeing with me on that point, that I try to point out before lordship that Millard, the prima facie view is that the banning order was bad. But the view with regard to jurisdiction clause, that this court has the jurisdiction to deal with, was not prima facie. That is a final finding. This section, this arbitration clause is not binding. That was not Millard a prima facie. That was Millard binding. And Millard, with regard to injunction can be granted, of course, that is prima facie. Millard, I had tried to make Millard two limbs of my lord's judgment of 30th July. And Millard, I have also relied on the judgment that Millard, in every stage, not only to the subsequent proceeding, in every stage, the subsequent stage is barred by res judicata if the earlier stage is not challenged or Millard recalled by a competent court, either by a lordship or by a coordinate bench or a division bench. Now, Millard, coming back to the point, Millard, I relied on Millard three judgments of this honorable court. Now, Millard, if Millard sees Millard the clause 50, Millard recollect, Millard, it says that civil court at Bokaro. Now, Millard, even if I go anywhere under the sun, Millard, any civil court could not have dealt with this. It has to be a quote-unquote commercial court. Now, Millard, a pointed question came from your lordship that Millard, Bokaro, the closest court, commercial court in Bokaro could have dealt with this litigation. My answer was, Millard, on the last occasion to your lordship's query was, pointed question was that this purported or alleged NIT is of 2022. So, Millard, I give full credit to my learned friends, officers and legal department that they have framed a policy after applying their mind or judicial mind, whoever in the legal department, that in 2022, at least Millard, in India, the commercial courts are fully operational. If this would have been in prior to 2015 arena, Millard, of course, Millard, I bow down to your lordship's Millard observation that Millard, it is prior to 2015. So in that point of time, nobody could have contemplated that commercial court will come. So civil court is being retained. So you have to go before the nearest civil court in Bokaro. But in 2022, Millard, every commercial court has been established. Millard had also found that Millard, commercial court is Bokaro is also there. But Millard, they had written Millet civil court at Bokaro. I relied on section 3, section 6 of the Commercial Courts Act before your lordship on the last occasion, saying that civil court cannot be considered as a commercial court. Commercial court is different genre altogether. So Millet, on that count, Millet, I'll just Millet take Millet the judgments, Millet, 2 minutes of your lordship's time. Millet is already, I've given the copies, Millet. Yes, one more thing I pleaded before lordship. Yes, just they, Millet, it's their case in the petition at page 43 and 45. They are later that the acts are of serious nature. The fraud are of serious nature committed by my client. Millet, my case was that if this is your stand, you have not changed your stand, or this stand is admitted by you, that this is of serious nature, that I have tampered with the number plate of the vehicle. So if the fraud, if this is your case, not my case, is of serious nature, then arbitration cannot be gone into, because Ayasami and Millet, all the judgments thereafter said, yes, fraud can be gone into, but not of serious nature. So if in your letter you are saying that this is of serious nature, then of course arbitration cannot be invoked. Millet have also relied on Shukonna holding that Millet, a plaint cannot be dissected. When Millet in Shukonna had said that section 8 should be dismissed if some reliefs are here and some reliefs are there. So Millet have also relied on Shukonna holding. Now Millet, hurriedly, I'll just Millet will kindly take Millet there. Just Millet will take not more than 2-3 minutes. Millet PD Light judgment 2009 SCC Online Calcutta 2533 of Justice Banerjee single bench. Nice. Millet, I have one copy, Millet, but it will Millet burden my lord's record.
What is the citation?
2009 SCC Online Calcutta 2533.
What is the party name?
Pidilite Industries.
Yes. Okay.
And kindly take the Millet first paragraph. Similar prayer was made. This is an application for revocation of leave granted under clause 12 of the latest patent in the alternative for dismissal of the suit in the further alternative for the plaintiff to be rejected. The first defendant applicant says that no part of plaintiff's alleged cause of action against the first defendant has arisen within the jurisdiction, and that it would be evident that the plaintiff does not have any cause of action against the first defendant and the plaintiff does not disclose any. No case has been made out for revocation of leave on the ground of balance of convenience. Now, Millet, kindly take the kindly leave one paragraph thereafter. Then Millet kindly takes the paragraph starting with the first defendant has also relied on Millet a forum selection clause contained in bills that were raised by the plaintiff on the first defendant. The relevant clause Millet set out. Now, Millet kindly takes the clause. The dispute this is referred to in the forum selection clause would be qua the individual bill. In any event, forum selection clause, notwithstanding its use of his word always, is vague in the sense that it does not specify the particular court in Mumbai that would be exclusively entitled to receive any action in respect of the bill. Further, the plaintiff's cause of action is on account of alleged fraud committed by the defendants upon colluding and conspiring with each other. The plaintiff's claim is not founded merely on the bill or the bills raised by plaintiff on the first defendant. Further, the plaintiff's action against the other defendants will not be subject to the forum selection clause. There is no merit in the application, neither can the leave be granted under clause 12 of the latest patent be revoked. So, kindly see the clause that is been quoted there. In case of legal dispute, the forum shall always be at Mumbai. So, in this case, in our case, civil court at Bokaro. So, anyway, I could not have approached civil court at Bokaro. This would have been immediately dismissed because this is a commercial dispute. This is the first. Next, I have relied on Tata Iron of Justice Banerjee's judgment, Tata Iron Steel, 2008, SCC Online, Calcutta 68.
Yes.
This is also regarding on the same line. Where an application was filed for revocation.
Yes.
Fine. I'm not getting the relevance. Paragraphs.
Yes, next.
This is of same line.
Paragraph
Para
20,
taken,
yes.
yes, Para has taken note of that. I will not waste Miller's time. Then had seen Justice Munshi's judgment, of course, unreported. Page 9 of that judgment of JK in engineering. Page 9, last paragraph onwards.
Yes.
This goes on. I will not bother your lordship with the it's with regard to it starts from page 9, last paragraph. It is also held in the same line following Justice Banerjee's judgment. That the referring court should be specific. Now, I have also relied on my lord's judgment of Descon. Copy Descon.
Yes.
In that judgment also, similar points were raised before your lordship, and my lord had held that the document that we are referring, that somebody, the litigant is referring, there has to be an express reference to the arbitration clause which is contained in another document.
Yes.
In this case, you will find that there is a specific document of the guidelines of banning guidelines. Now, that banning guidelines does not bear any reference to the any NIT. Neither the arbitration clause nor the the jurisdiction clause. So, if takes the those are there, that the banning guidelines, will not find that the banning guidelines, kindly had also already made a note. Banning guidelines are at page 52 of GA1.
Yeah, GA1. Yes.
52 of okay, কথা বলবো অন্য কথা বলে 52 of GA1.
Yes.
This banning guidelines, my lord will not find any reference to the arbitration clause or jurisdiction clause. So my lord's judgment is applicable in this case that the primary document that is being relied upon should have a reference.
Yes.
And not only the cursory reference, there should be a specific reference to the arbitration clause containing another document. Number 2, if my lord takes section 8 application GA3, kindly takes the page 81 of GA3.
Yes.
My lord will find somewhere around the middle NIT number STA case. My lord, last occasion my lord had directed my learned senior friend on my other side that to take instruction what is STA case. Now my lord, now if my lord takes the guideline, my lord, which the primary sheet anchor of my learned senior friend's case kindly comes to page 72.
Yes.
At the top, LTE case.
Yes.
So I have the full form of LTE, it's limited tender inquiry cases.
Yes.
But I have no knowledge, I have tried to inquire. STA cases are something different. Number 1. Number 2, now again comes back to page 81 once again. My lord will find that the NIT has a number. That NIT special remarks, middle of the page 81. That NIT has a number CCNW22-23 LT700. But it kindly comes back to page 81, special remarks middle.
Special remark.
The invoice, job order. Kindly see special remarks in all the scope and terms and conditions of the NIT number such and such.
Special remark.
Yes.
Endorsement number.
Yes.
Okay. And
NIT number CCNW has my lord found 81 of GA3.
NIT number CCW23 22 LT. Yes.
If my lord comes back to 72, this is at least this is not that NIT. No number given, no date given. Their defense was that my signature is appearing at the bottom. I again submit before lordship the risk of repetition. I am doing 100 projects with them.
Yes.
So whether this is that NIT or not, there is a subject matter of has to be seen, gone into by a lordship. Now, if takes GA1 again once more.
What is the NIT number?
NIT number, they say that CCNW, the job order says so, but the NIT that they have enclosed does not bear any number.
That's why this.
It only says that with reference from 5/9/2022, this will be applicable. Kindly see page 72. It does not bear any number. It seems that it's a general, not specific one. NIT terms and conditions effect from 5/9/2022. No number. So in my job order, there is a number. CCNW 22-23 LT 700.
Yes.
This has no number. Now again comes back to GA1 once again. Now kindly takes page 45.
Yes.
45. Letter of 8 September 2023. Now, will kindly see third paragraph. Since the allegations are of serious nature, it has been
You already pointed out.
yes, these are the things. Now, Millet, if this is the issue that is their stand that the allegations are of serious nature, Millet, this cannot be dealt with in arbitration. Now, Millet, I'll rely on a Millet Delhi High Court judgment. First, Millet, I rely on 2010 1/72. Millet, this is new for today. 2010 1 SCC page 72. Let's give me a moment. Yes, I have a copy. Sorry. Millet, it has been copied from my copy, so Millet paragraphs number. Well, kindly takes page 7, paragraph 7. So sorry. Millet, section 8 application was dismissed. Now, Millet, facts are being given. Now, Millet, kindly takes paragraph 13. We are not in a position. We are 13. We are not in a position to determine the veracity of the statements of either parties. The main issue which needs to be determined is to whether the case falls within the jurisdiction of the arbitrator, and if it does, whether the procedural requirements under section 8(2) of the Act had been complied with to the satisfaction of the court. Then we are 21. 21. In our opinion, the contention of the respondents relating to the jurisdiction of the arbitrator to decide a dispute pertaining to a matter of this proportion should be upheld in view of the facts and circumstances of the case. The High Court in its impugned judgment has rightly held that since the case relates to allegations of fraud and serious malpractices on the part of the respondent, such a situation can only be settled in a court through furtherance of detailed evidence by either parties, and such a situation cannot be properly gone into by the arbitrator. Then 23. The learned counsel appearing on behalf of the respondents on the other end had contended that the appellant had made serious allegations against the respondents, alleging that they had manipulated the accounts and defrauded the appellant by cheating the appellant of his dues, thereby warning the respondents with serious criminal action against them for the alleged commission of criminal offences. In this connection, reliance has been placed on such and such. Then 26. Judgments are quoted. Then 26. In the present dispute faced by us, the appellant had made serious allegations against the respondents, alleging them to commit malpractices in the accounts books and manipulate the finances of the partnership firm, which in our opinion cannot be properly dealt with by the arbitrator. As such, the High Court was justified in dismissing the petition of the appellant to refer the matter to an arbitrator. In this connection, it is relevant to refer the observation made by the High Court in its impugned judgment. Then, my lord, kindly takes me paragraph 27. Arguments were favored by either parties relating to the ambit of section 8(2) of the Act, wherein the scope of the mandatory requirement to file the original copy of the partnership deed dated such and such or elaborately discussed. It is to be noted that since we have already decided there is no requirement to appoint an arbitrator in view of the matter, that the issues involved in the case involve detailed investigation into the same and production of elaborate evidence to prove the allegation or refute the same, there is no need to dwell into this matter. Even assuming that a dispute subsists and an arbitrator is appointed, still the appellant cannot absolve himself from the mandatory requirement of filing an original copy of the deed. Now, at this point, I'll also take Miller, because Miller 8(2) contemplates original Miller arbitration clause. Original document has to be appended. Now, Miller kindly takes 29. But it is to be noted herein that the claim of the appellant regarding the dispute was under the arbitration clause mentioned under the original partnership deed and not on the subsequent one. Since the original deed was not filed within the requirement of 8(2) of the Act, it must be held that the mandatory requirement under the Act had not been complied with. Accordingly, even if we accept the factum of dispute relating to the retirement of the appellant under the original deed dated 7th April 2003, still the court would not be empowered to refer the matters to an arbitrator due to the non-compliance with the provisions mentioned under section 8(2) of the Act. Now, ultimately, it was for the aforementioned reasons and in view of our discussions made here, we therefore do not find any merit in the appeal. We direct such and such. So, number 2 issues are decided: fraud and malpractices, and the second issue is that 8(2).
Yes, next.
2008 2 SCC 602. Paragraph 13, 16 and 19. It has been 13, 1-3.
Yes.
It has been further urged that there was non-compliance with the subsection 2 of section 8 of the 1996 Act, as the application moved by defendant number 3 was not accompanied by the original arbitration agreement or on duly certified copy thereof, and therefore the same ought to have been rejected. See, such an senior counsel for the respondent has submitted that the plaintiffs in fact are claiming rendition of accounts and their share in the partnership business, for which they are basing their claim on the partnership deed, to which Sri such and such was a party, and the said deed contains an arbitration clause. In such circumstances, the High Court rightly referred the dispute for arbitration. Then 16. It is an admitted fact that neither Rajendra Prasad Singh nor are the plaintiffs parties to the partnership deed dated such and such. There is no document as defined in section 7 of the Act which may contain the signature of either Rajendra Singh or the plaintiff. Similarly, there is no document as contemplated by clause B, C, and 4 of section 7 of the said Act, from which it may be spelled out that either Rajendra Prasad Singh or the plaintiffs are parties to clause relating to the arbitration contained therein. It is also an admitted fact that such and such was alive when the said partnership deed was executed. Therefore, on the face of it, section 8 would not apply. Then 19. There is no whisper in the petition that the original arbitration agreement or a duly certified copy thereof is being filed along with the application. Therefore, there was a clear non-compliance with subsection 2 of section 8, which is a mandatory provision that the dispute could not have been referred to arbitration. Learned counsel for the respondent has submitted that the copy of the partnership deed was also on the record of the case. However, in order to satisfy the requirement of subsection 2 of section 8, the defendant number 3 should have filed the original arbitration agreement or a duly certified copy thereof along with the petition filed, which he did not do so. Therefore, no order for referring to arbitration. Similarly, I rely on section 8(2).
Yes.
Paras relied on a Delhi High Court judgment of Bentwood sitting, because I'm not finding a copy with me. The marked copy.
What is the name?
Bentwood Sitting Systems, Delhi High Court, of 11th March 2025. I have a copy. So, sir. একটা ওটা আনরিপোর্টেড আমি এটা তোকে দিয়ে দেবো, হ্যাঁ ছবি তুলে সাইডে আনরিপোর্টেড। আই জাস্ট ওকে বললো ছবি তুলে পাঠিয়ে দেবো। Means it's a unreported judgment of learned single judge of Honorable Delhi High Court. Kindly comes to paragraph 10. Paragraph 10. Page 30. Issue number A, B, and C were dealt as preliminary issues, as the arbitrator wanted to first consider as to whether disputes which have arisen in the arbitration were arbitrable at all or not before permitting the parties to lead evidence. The learned sole arbitrator, by way of impugned award, held that the appellant had played a fraud on the respondents in getting the tender, and the extent of fraud is such that it would be difficult for the learned sole arbitrator, which is not a court, to summon witnesses from various governmental authorities and foreign companies. May I pause here for a moment? Miller, in this case, if Miller the matter is referred to arbitration, Miller BSF Jawans will have to be called, because Miller they are the Miller. This also their case and my case, that they are who first confiscated the goods and Miller the truck or trailer at the gate. So Miller they have to be brought into Miller before the arbitral tribunal. Now Miller the arbitrator held that the fraud in the present case cannot be confined to the internal matters affairs of the parties therein. The allegations of fraud of documents which pertains to a fabrication of documents of foreign companies and governmental authorities cannot be adjudicated upon or examined by the arbitral tribunal, which does not have the wherewithal of a court. The learned sole arbitrator placed reliance Miller on Vidyadhara such and such. Then Miller learned's paragraph 11, learned sole arbitrator had held that the dispute is not arbitrable, and the impugned award therefore falls within the realm of section 16 of the Act of 1996. The appellant has now approached this court by filing the instant appeal under section 37 2A. Now Miller kindly takes Miller 15, paragraph 15. The issue arises for consideration in the instant appeal is as to whether the learned sole arbitrator ought to have permitted the parties to lead evidence and adjudicate the issue of fraud, or is a decision taken by the learned sole arbitrator that the issue which arises for consideration in this case is not arbitrable, looking into the nature of fraud that has been played. Now Miller paragraph 17, the definition of fraud has been Miller set at 17. The allegation against the appellant is that the appellant has submitted the two SPCs to depict that the end users of PBT is manufactured by foreign original manufacturer, namely SJM, where Heathrow Airport, United Kingdom, and Noi Boi International Airport, Vietnam. It is also stated that the appellant has submitted an authorization letter purportedly given by SJM to represent itself as the Indian associate of foreign original manufacture to make it eligible to participate in the tender. It is the creation of the two SPCs and authorization letter which is to be examined as to whether they are product of forgery or are the originals. These documents are therefore the heart of the matter, and if these documents are proved to be forged or fabricated, then the appellant has committed a fraud on the respondents as defined under section 17 of the Contract Act. The civil and criminal courts have to adjudicate the issue. Undoubtedly, both the proceedings can go on simultaneously, and one is not necessarily dependent on the other. But in both the civil and criminal cases, these documents will have to be tested. It is in this light the court has to consider whether the finding of the learned sole arbitrator holding the disputes as non-arbitrable warrant interference. The parameters which have to be kept in mind while deciding as to whether allegations regarding fraud are arbitrable or not is now well settled. Then Miller ISME judgment is quoted. Miller, I am skipping Miller those paragraphs. Finally comes from paragraph 23. 23. Yes, at page 34 or 36. 23.
Yeah.
The bench of 3 judges therefore held that serious allegations of fraud ought not to be adjudicated in arbitral proceedings and are best left to the courts. The arbitral tribunal, after applying the law laid down by Apex Court in Ayasami, Rashid Raza, and Airway Post Studios and Vidyadhara, came to the conclusion that the facts of present case are complex in nature. The arbitral tribunal would have to be examined witnesses who are officers from governmental authorities and also those outside the country, and therefore it is difficult to summon those witnesses before the learned sole arbitrator. The learned sole arbitrator would also have to take assistance of the Ministry of External Affairs to summon those witnesses, which can be more expediently handed over the civil courts than the arbitral tribunal. The allegations of fraud are not of forgery but fabrication of documents of foreign companies, authorities, and therefore this could more be conveniently adjudicated by the civil court than by the arbitral tribunal. The facts of the present case reveal that it took substantial amount of time by the respondents to unearth the fraud of the appellant. The respondents had to send repeated emails to Heathrow Airport, United Kingdom, and Noi Vai International Airport, Vietnam, to take the assistance of the Ministry of External Affairs and contact the Indian consultants. The Indian consulates had to take steps to contact the SGMs, though whose emails revealed that SGM was reluctant even to come to Indian consulate for a meeting. Though the arbitral tribunal has been conferred with powers under Section 27 of the Act of 1996 to call for witness, this court is of opinion that the view taken by learned sole arbitrator that it would be more easy for the civil court to summon witness, that is officials at the Heathrow Airport, United Kingdom, and the Noi Vai Airport at Vietnam, and officials of the SGM to give evidence for unearthing core issue, which is as to set whether the species which has been produced by the appellant is fabricated or not. If the documents are fabricated, then the appellant has taken the benefit by the forged and fabricated document, and the appellant cannot be permitted to take a premium on fraud which is alleged to have been committed by them, and courts cannot be mute spectator to such fraud which is alleged to have been committed. The conclusion of the learned sole arbitrator that the court is better equipped to adjudicate these issues therefore does not call for any interference. It cannot be said the learned sole arbitrator has taken a cursory view regarding the fraud. The issues added are complicated and complex in nature. So in my case also, the issue is that I have caused malpractice with the number, change the number plate, cause fraud, and BSF Jawans have held me on the outgate of the plant. Now the next point which I convert to lordship I shall rely on Sukarna holding, which I have not relied earlier. I just made a reference to that. 2003 5 SCC 531. Sukarna Holdings has also been dealt with by Vidyadrolia, paragraph 29, it has been upheld. Paragraph 29 of Vidyadrolia. Finally comes to paragraph 4. The appellant filed an application under Section 8 of the Arbitration and Conciliation Act 1996. The application was kept hearing along with the notice of motion. Subsequently, respondent number 1 filed fresh suit bearing number such and for dissolution of the suit firm accounts.
Where
and
from you are reading?
Paragraph 4, then 5-7.
Yes.
And other reliefs, including the reliefs for setting aside the transfer of suit flats in favor of various defendants. The respondent withdrew the suit filed on such and such. Then 7. The High Court by its judgment and order dated 18th of September 2001 rejected application under Section 8 of the Act. The court arrived at the conclusion that in the suit, apart from the reliefs of dissolution and accounts, the plaintiff has paid for other reliefs. All the defendants to the suit are not parties or partners in the partnership firm, and the terms of the partnership deed, including the arbitration clause, are not binding on them. Only part of the subject matter could at most be referred to arbitration. Further, there is no power conferred on the court to add parties who are not parties to the agreement in the arbitration proceedings. The court also negativated the alternative prayer for referring the part of subject matter in respect of whose parties who are parties to the partnership agreement which contains arbitration clause. The court arrived at the conclusion that such procedure is not contemplated under the Act. The object and purpose of the Act is to avoid multiplicity of proceedings and not to allow two forums simultaneously to proceed with the matter. The judgment and order is challenged in this appeal. Kindly take paragraph 13. Secondly, there is no provision in the Act that when the subject matter of the suit includes subject matter of arbitration agreement as well as other disputes, the matter is required to be referred to arbitration. There is also no provision for splitting the causes of action or parties and referring the subject matter of the suit to arbitrators. Thirdly, there is no provision as to on what is required to be done in a case where some parties to the suit are not parties to the arbitration agreement, as against this under Section 24 of the 1940 Act. Some of the parties to the suit could apply that the matters in difference between them to be referred to arbitration. The court may refer the same to the arbitration provided that the same can be separated from the rest of the subject matter of the suit. Now, kindly comes to paragraph 16. The next question which requires consideration is, even if there is no provision for partly referring the dispute to arbitration, whether such a course is possible under Section 8 of the Act. In our view, it would be difficult to give an interpretation to Section 8 which bifurcation of the causes of action, that is to say the subject matter of the suit, or in some cases bifurcation of the suit between the parties who are parties to the arbitration agreement and others is possible. This would be laying down a totally new procedure not contemplated under the Act. If bifurcation of the subject matter of the suit was contemplated, the legislature would have used the appropriate language to permit such a course. Since there is no such indication in the language, it follows that bifurcation of the subject matter of an action brought before a judicial authority is not allowed. Accordingly, Section 8 was dismissed. Kindly takes Mr. The learned senior on my other side had referred to Vidyadolia. The copy is there, I'll take advantage of that.
Yes.
Yes, paragraph 28, page 51 of the judgment.
Yes.
Another facet, paragraph 20, another facet not highlighted earlier arises from the dictum in Sukanya Holdings, a decision upholding rejection of an application under Section 8 on the ground there is no provision in the Arbitration Act to bifurcate and divide the causes or parties, that is subject matter of the suit or judicial proceedings, and parties to the Arbitration Act. The suit should be in respect of a matter which the parties have agreed to refer and which comes within the ambit of the arbitration agreement. The words "a matter," it was interpreted, would indicate that the entire subject matter of the suit should be a subject matter to arbitration agreement. Bifurcation of subject matter or causes of action in the suit is not permissible and contemplated. Similarly, the parties to the suit should be bound by the arbitration agreement, as there is no provision in the Arbitration Act to compel third parties who have not exercised the option to give up the right to have access to courts and be bound by the arbitration clause. This would violate party autonomy, consensual nature of arbitration. Bifurcation in such cases would result in a suit being divided in two parts, one being decided by arbitral tribunal and the other by the other courts or judicial authorities. This would defeat the entire purpose and inevitably delay the proceedings and increase cost of litigation, cause harassment, and on occasions give rise to conflicting judgments and orders by two different fora. Cause of action in relation to the subject matter relates to the scope of the arbitration agreement and whether the dispute can be resolved by the arbitration. So ultimately it was upheld by Vidyatrolia, the case of Sukanya Holdings. Now coming back to the judgments of my learned senior friend, I will like to rely on the judgment relied upon by him. I rely on that 2024 ACC Online Calcutta 6369, by him, by sale it was. Yes, 2020 ACC Online Calcutta 6369. Shobhoshachi Bhattacharya. Yes. Kindly comes from paragraph 32.
Yes.
Well, in the said case, it was held that if a case stipulates that under certain circumstances there can be no arbitration and they are demonstrably clear, then the controversy pertaining to appointment of arbitrator has to be put to rest. In the said case, as evidence from the para 7 thereof, the arbitration clause has a clear negative provision that is clearly agreed and understood that no difference or disputes shall be referable to arbitration as therein before provided, if the company has disputed or not accepted liability under or in respect of the policy. The said circumstances cannot be equated with the present case since there is no negative clause in the arbitration clause therein. 33, the respondents also cites the judgment of Hyundai Engineering, where there is also similar clause restricting the reference to arbitration if the company has disputed or not accepted liability under or in respect of the policy. In the said case, it was clearly agreed between the parties that the matter shall be referred to arbitration only if the quantum was disputed, thereby confining the reference in specific terms to dispute as to the quantum alone. In such context, the strict construction of the clause was mandated by the Supreme Court. In the present case, however, there is no negative clause specifically providing in the negative terms that there would have been no reference if the company has disputed or not the accepted liability in respect of the policy. Now, let's kindly see. Hello.
What the point?
The point, Millard, I want to Millard in this case, Millard Justice Bhattacharya has held Millard self-destructive. I have lost that paragraph. Yes. I'm so sorry. Paragraph 26. The post-it I missed, Millard. Seen 26. Millard, end here for today, Millard. 26. Seen from another perspective, clause 14, which is the forum selection clause, cannot be divorced from the arbitration clause so as to stand on an entirely independent footing. The selection of a forum cannot exist in thin air, but is directly relatable to the dispute which is to be decided by such forum. Hence, an indication of the scope of disputes to be decided before the forum can also be derived from the forum selection clause. Conspicuously, clause 14, which confers exclusive jurisdiction on the courts in Calcutta, uses the expression in case of any dispute or any differences between the parties arising out or in relation to the agreement, entirely omitting the term validity. The forum selection clause has to be read along with the arbitration clause, since it does not supplement but supplements the arbitration clause, qualifies the same, providing merely the forum for redressal of the dispute which are indicated there. Hence, there must be an identity in the ambit of disputes covered by the arbitration clause and the forum selection clause. Otherwise, it would be absurd and unworkable if the forum selection clause covers the wider dispute than the principal arbitration clause. Hence, clauses 13 and 14 are to be read together in the import meaning. Then we have 28. 28. The expression courts has been sought to be explained by the respondent to mean only regarding suits and not arbitration. However, in such event, clauses 13 and 14 would be mutually exclusive. So let's say in our case, leading to the impossible conclusion that in the same breath, the parties chose to refer the dispute to arbitration, but at the same time provide for civil suits. In the forum selection clause, notably, the expression court has also been defined in the Arbitration and Conciliation Act, and as such may very well mean the adjudication by the courts in Calcutta in respect of the matters referable in connection to the arbitral proceeding. So I am saying the same thing. In the same breath, I cannot say arbitration. In the same breath, I cannot refer to suits. Similarly, there will be those are mutually destructive to each other, and you will create a confusion.
Yes.
May I end here for this day, Millard? I will come back with the dealing with the other judgments.
Sense suffering for the plaintiff, sense suffering for the defendant. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. So both application is taken, na? 1 and 3.
Mine is
3. This is hearing of 3.
3, but I'm referring to 1 also because Millard, the pleadings are Millard.
1 is with regard to interim order.
Yes.
1 and 3. Okay? Yeah. But hearing could not be completed. According to cases adjourned, let the matter appear on May 5th.
The interim order expiring on 25th.
25th.
Yes, this Friday.
Counsel for the plaintiff submit the interim order granted earlier is going to be expired on 25th of April 2025. Accordingly, interim order is extended till 8th of May 2025 or until further order.
Millard, any day, 6th, 7th, 5th, I have some.
8th.
No. Matter to return.
5th, you are a difficult.
5th, Millard, I am something.
Then 7th.
7th.
My lord, the next matter, my lord, very short matter, innocuous period I'm asking for.
Which one?
My lord, the next matter, item number my lord, 15, my lord.
I'm for the defendant number 1, my lord.
My lord, just kindly seize the last order.
Item number?
15, my lord. My lord, kindly seize the last order of 20th of February 2025, where, my lord, I had taken time on behalf of the plaintiff to file an additional written statement to the counterclaim included in the written statement. Now, my lord, after I have received a copy of the counterclaim, my lord, I believe this is not a counterclaim but a simple written statement only because the prayer
dismissal of the suit.
Because the prayers, my lord, is decree of dismissal of the claim of the plaintiff, decree of dismissal of the suit, decree for declaration that the suit is not maintainable. So if they say that this is not a counterclaim, I need not use an additional written statement.
Which order you are referring?
My lord, I'm referring to the counterclaim which has been filed by the defendant, my lord. না না GA3 না এই সুটে যে কাউন্টার রিটেন স্টেটমেন্ট ফাইল করেছে ওইটা একবার দিন
মোটা হবে দেখুন
ভলিউম 1 টা
নেই এখানে নেই আরেকটা দেখুন
may I hand over a copy of the written my lord, kindly seize the prayers made in the written statement. It's styled as a written statement but it had a couple of prayers, my lord, at page 57. So, my lord, I need not use an additional written statement if the defendants say that it's a written statement and not a counterclaim. So, my lord, if we avoid that,
only asking for dismissal of the suit, my lord. The prayer is like that.
But paragraph 38.
But you kindly seize the relief. They are seeking dismissal of the suit that the plaintiff's claim is not correct. So this is in effect an opposition or a defense. Is this? If my lord says I will come back, I'm beyond 30 days.
What the court will say? If you are telling that you will not.
If my learned friend says that this.
Since my lord, this is I'm asking for only dismissal of the suit, your lordship. We are filing the W. There is no counterclaim from our end.
There is no counterclaim.
My lord.
No,
it was written. Yes, lord. That is written in terms of that, but it was kind of bad drafting, my lord.
No cause of action paragraph. They have
but 37 years.
Yeah,
rather, the defendant number 1 is entitled to get 2 lakh, 2 crore,
but
28
even then, my lord, for a
25,000.
counterclaim, my lord, they have to pay
No,
court
that-
fees. Damn, nothing.
That's correct. But if you say, then I will record your.
But I have been instructed that there is no counterclaim, my lord.
So this written statement was accepted.
Yes, your
It
lord.
was accepted, my lord, because the suit was initially filed before the ordinary original civil jurisdiction. Subsequent to transfer, my lord, it was
By order dated 12.
You are appearing for the defendant. All the defendant.
One. Defendant number 1, your lordship.
So list of the defendant number 1 has filed the written statement. Filed the written statement, but in paragraph in paragraph 37 and 38, comma, the plaintiff and the defendant has stated that the defendant number 1 is entitled to get an amount of rupees 2,28,75,000 from the plaintiff's or its director. And it is further stated that the defendant number 1 further stated that no claim of the defendant number 1 is barred by limitation as the cause of action is running and continuous till the vehicles are returned or handed over to the defendant by the plaintiff. Okay? Full stop. The counsel for the plaintiff has drawn the attention of this court to the prayer made in the written statement, wherein the defendant has prayed for a decree of dismissal of claim to the tune of rupees 10,77, 15,860, along with the interest at the rate of 18% per annum, dismissal of the suit as claimed by the plaintiffs, including the prayer of injunction, decree for declaration that the suit is not maintainable against the defendant number 1, filed by the plaintiff. Full stop. When the plaintiff has drawn the attention of the prayer made in the written statement, the counsel for the plaintiff, counsel for the defendant number 1 submits that though the defendant has stated about the claim of the defendant in paragraph 37, 38, but in the prayer portion, the defendant number 1 has not claimed any amount from the plaintiff, and he submit that the written statement shall not be treated as counterclaim. This can be only treated as a written statement. Accordingly, as per the submission made by the counsel for the defendant, number one, the written statement filed by the defendant number one shall be treated as written statement and not the counterclaim.
We may come back with issues, my lord.
Full
and
stop.
Discovery
The-
inspection and
As full stop. In view of the full stop, the parties are directed to complete the discovery and inspection of the document within 3 weeks.
kindly gives us 4 weeks, my lord.
Within 4 weeks. Full stop. Affidavit of admission and denial of the document be filed within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. 4 weeks, 2 weeks, 6 weeks. Na? Let the matter appear on 27th June 2025 for framing of issues.
I'm extremely grateful to
Grateful, my lord.
My lord, may I file to the plaintiff my notes of argument apropos the defendant number 3's counterclaim, my lord. I had already filed my notes in respect of the claim of partition. This primarily, my lord, on the basis that they have failed to.
This with regard to
counterclaim of the defendant number 3.
Okay. Other, all are filed.
No, my lord, I need to file my additional notes, my lord. It's on my way, my lord. On
the officer.
We'll file it with your lordship's court officer.
And 5.
File number 4 and 5. And what about you?
I have not filed.
You will not file.
Defendant number 3, your lordship, we have
Already filed.
Yes, your lordship.
But so far as my defendant number 2 is concerned, my lord, it's
You
on
file
its
in
way,
time.
my lord. We'll file it with your lordship's officers.
So finally, after 2012, since 2012, the hearing is concluded in 2025.
I don't think when I will get the time to deliver before vacation.
No,
Because
Yes.
mid of the May, I have to go to the circuit.
Oh, understand.
Otherwise, I could do it. Let us see.
Well, it will take my lord's time, my lord.
So suffering for the plaintiff, so suffering for the defendant number 2, so suffering for the defendant number 3 series, and so suffering for the defendant number 4 and 5. Counsel for the defendant number 4 and 5 submitted. They will not use any data notes. They will not file.
One. I am one.
One for 4 and 5.
4 and 5 are
Filed.
They are filed.
Counsel for the defendant number 1 submitted. He will not file any affidavit, written notes of argument. Full list. Counsel for the plaintiff has filed written notes of argument against the contract claim of the defendant number 3. Full stop. And what is this? And defendant number 4 and 5 also filed the written notes of argument. The plaintiff and the defendant number 3 series have already filed the written notes of argument. है ना हमारा record में है? Already filed the written notes of argument. CAV.
But if your lordship kindly records my defendant number 2, my lord, will file it during the course of them.
As well as the defendant number 2.
I'm so
obliged.
Grateful.
Lordship, we are for the propounders, petitioners herein.
Yes.
And for the respondent.
On the last occasion, on the 16th and 17th, much prior to that, Mr. Datto had already indicated that he will not be available on 16th, 17th. On the 16th, I appeared before your lordship. On the 17th, 16th, I appeared before your lordship mentioning the matter.
Now what you want?
Today is listed for fixing a date, your lordship.
Correct.
They want to give reply to our argument. My lord, they had
And
placed their
today is
argument.
for
We had
fixing a date for us coming back to reply, coming in reply with them.
When you will come?
Your lordship.
Vacation?
No, your lordship, much before the vacation, if possible, this week.
It is not possible.
Friday, your lordship. This week, if possible.
If I may request 1 and 1st and the 2nd May, if that would be convenient. But I'm being led by Mr. Kollol Basu. It would be convenient for him. I have taken it.
You just have to listen. We have to give in reply.
First and second.
Yes,
But we have to
That
we have to submit, your lordship. If it can be any time this month itself, if it is possible, your lordship.
May I file the mullet?
or any day, as my lord pleases. Any day.
Earliest date possible, your lordship.
कब कुछ date है मेरे? I
Most
don't think we are
complete.
before June.
Sir,
For
your
June, there
lordship.
is no date. All fixed matters. में क्या होगा? 15 में हम लोग कुछ करेंगे.
Just I would like to indicate to your lordship this they finished. We are on reply, your lordship. If it happens sometime before this side of the vacations, it will be fresh.
No, I can fix it, but I don't know whether the time can be given.
Yes, if it doesn't reach, then it's not
correct. No, it will. If time I cannot fix a specific time, it will be in the list. अच्छा दे तो भी है ना, non-commercial है ना. Then it will be Friday.
Friday is fine with us, your
No,
lordship.
it will be listed Friday, but I
Just a minute.
don't know whether it will be taken up because all other matters also be in the list.
How do you? No, not June. We are wanting to do it in this side. Everything with
Expert
arguments
सब
are
दो
it's lost its way. So much time passes.
2-3 सब फिक्स है. 2 बजे 3 बजे सब फिक्स है.
Without a time being.
Sorry.
then come on 2nd May को इसको ऊपर रख दो argument को.
Your Lordship, we'll try to finish our reply within one session, Your Lordship. In case it spills over, 2 sessions may be granted.
That's why I'm telling. Because if you also complete on 5th or 6th, there is no time to this court to deliver judgment. 8th May, 3 p.m. खाली है.
Second is fine.
8th May.
Second, Your Lordship, is much better.
2nd May, I am giving because on that day origin side matters will be taken. This non-commercial matters will be taken.
Second and 8th, then, Your Lordship?
2nd and 8th. 2nd में time नहीं है. उसमें ऐसे रहने तो list में. So suffering for the plaintiff, so suffering for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. It is fine from the record. The matter is at the stage of argument, and the parties have argued the matter at length. According counsel for the plaintiff prayed for fixing the matter. In view of the above, let the matter appear on 2nd May as well as on 8th May. 2nd May no time होगा, and 8th May at 3 p.m.
Much obliged, Your Lordship.
Yes. Yes.
I appear for the defendant.
May it please your lord.
Yes.
I am appearing on behalf of the review applicant.
Who is for the other side?
I appear for the defendant. I am opposing this.
Yes.
Your lordship
The
was
ground of
pleased to.
review.
Yes, my lord, your lordship was pleased to pass an order dated 24th of April 2024. By this order, my lord, while adjudicating a suit for recovery of money lent and advanced and my application for judgment upon admission, your lordship held that because there are multiple transactions of advancement of loan, this must be understood as a money lending business. My lord, if your lordship takes up the application volume 1, your lordship's order begins from page 14. The appropriate observation of your lordship, my lord, is at page 23, which is internal page 10 of the or page 22, paragraph 16 and 17. Considering the above circumstances read with section such and such of the Act of 1940, the court finds that the plaintiff is running the business of money lending, and admittedly the plaintiff has no license under the said Act. Thus, as per section 13(1) of the Act, no decree can be passed in the instant application. The court has held that the plaintiff is having the business of money lending without any license and no decree can be passed. Thus, this court has not gone into the facts whether the defendant has unconditionally and unequivocally admitted and acknowledged the amounts claimed by the plaintiff. So, Lordship was of the view that I am a money lender and my application for judgment upon admission cannot be proceeded with because of the embargo under section 13 of the Act of 1940. But my only point of submission before your lordship is that there is perhaps no mistake of fact in your lordship's order, but a mistake of law is also reviewable. That is Board of Cricket Council of India versus National Cricket Association, Calcutta, 2005 Supreme Court. That is there, very clear. The judgment is there, and I shall cite if necessary, Milord. The transaction between the parties, which is advancement of loan, admittedly, Milord, was multiple in number, but each and every of those transactions was through check, and that is beyond the purview of the 1940 Act. May I show, Milord, your lordship, the plaint I have set out, Milord, how it was made. Page 32. The plaint begins, Milord.
Yes.
And next page at paragraph 3, we have given, Milord, details of the the particulars of the loan transactions. Your Lordship, my lord, for an example, can see 50 lakh of rupees was made over by RTGS. These RTGS were real-time gross transfer, my lord, were drawn through checks, and we have annexed each of such forms where individual check numbers are written at page 48. It begins at page 48 and continues, my lord, till page 69. If your lordship is at page 48, your lordship will find that it is such and such bank application for fund transfer under RTGS. Please remit a sum of rupees 1 crore to account number such and such. This account is of the defendant. As per details given below, check number such and such, dated such and such, favoring Axis Bank, RTGS from Shudha Kankana is enclosed. So, Miller, these are the checks. Now, the only point which I would like to, Miller, submit before your lordship, that since it is check, comes within the purview of negotiable instrument, which, Miller, is outside the purview of the 1940 Act. Then may I rely on one judgment passed by coordinate bench, Miller? Miller, if I get hold of the reported citation, I will definitely supplant. Petitioner seeks an order of injunction against the respondent in receipt of money lent and advanced by the petitioner to the respondent on various dates, from May 2017 to February 2018, of a principal sum of rupees 7 crore 50 lakh. But in our case, it is 3 crore 60 lakh. The said amount was paid by the petitioner to the respondent by way of 5 checks drawn on Axis Bank. According to the petitioner, the money was given as loan pursuant to requests made for such by the respondent and at an agreed rate of interest at 15% per annum. Mr. Such and Such, learned senior counsel, appearing for the petitioner, submits that an interim order is called for since the respondent has denied the loan facility in its entirety. Counsel places bank accounts. Milord, I'm not going into so much of details. Milord, kindly come to the last line of page 2. Mr. Such and Such, learned senior counsel, and Such and Such, Milord, who's now a judge, appearing for the respondent, resist the prayer for injunction on the ground that the respondent has already filed written statement. Now, Milord, in the middle of the page, counsel takes a preliminary objection to the maintainability of the application on section 13 of the Bengal Moneylenders Act 1940, which, according to counsel, bars a court from passing decree or order in favor of a moneylender in a suit instituted by a moneylender for the recovery of a loan advanced, unless the court is satisfied that at the time when the loan was advanced, moneylender held an effective license. This is, Milord, exactly what was submitted on behalf of the defendant, and based on that submission, Milord, your lordship has passed an order. Milord, kindly come to the last line of page 3, where the observations begin. It begins with the word, I have considered, your lordship, Milord, is, I have considered the materials on record in course of submissions of learned counsel appearing for the parties. Before dealing with the factual contentions, the point of maintainability must first be addressed. Section 13 of the Bengal Moneylenders Act 1940 prohibits a court from passing a decree or order in favor of a moneylender in a suit filed by a moneylender for recovery of a loan advanced, unless the court is satisfied that the moneylender held an effective license at the time of granting the loan or advancing any part thereof. The other parts of section 13 are not relevant for the purpose of this application. Section 2, subsection 12 of this act defines a loan as an advance, whether on any monetary terms or in kind, made on condition of repayment with interest, and includes any transaction which is in substance a loan but does not include an advance made on the basis of negotiable instrument. This is important, Milord. Does not include an advance made on the basis of a negotiable instrument as defined in the Negotiable Instruments Act, other than a promissory note as provided under subclause 12E. Under section 13 of the Negotiable Instruments Act, a negotiable instrument has been defined as a promissory note, bill of exchange, or check payable either to order or to bearer. A conjoint reading of the provisions under the Bengal Moneylenders Act and the Negotiable Instrument Act makes it evident that a loan advanced by way of a check within the definition of a negotiable instrument would fall outside the purview of a loan under the Bengal Moneylenders Act, and hence outside section 13 of the same, which bars a court from passing a decree or order in favor of a moneylender in a suit filed for recovery of loan advanced unless the court is satisfied that the moneylender held an effective license on the date when the loan was advanced. The part with regard to requirement of a moneylender holding an effective license becomes irrelevant since the loan given by the petitioner to the respondent in the present case clearly falls outside the scope of the Act by reason of the loan being advanced by the petitioner to the respondent by way of 5 checks drawn on the concerned bank at different points of time. This is, my lord, the portion which I wanted to rely upon. The remaining portion, my lord, an order for attachment before judgment was eventually passed. In our case, my lord, I have also shown your lordship that these advances, which cumulatively quantify to rupees 3 crore 60 lakh, all were made through, my lord, checks recorded as RTGS, and one has to draw check for this real-time gross transfer, and those check numbers are there. This cannot be a disputed fact, my lord. Hence, in my most humble submission, my lord, if your lordship would be pleased, my lord, to modify the order to the extent of reviving the application of judgment upon admission, and we may proceed with the hearing of the application for judgment on admission at any suitable date your lordship may fix.
Okay.
These are my submissions. I only reserve my right to address my learned friend if he says that the review is not maintainable. Then I'll show that BCCI's judgment.
So far as
oh, my lord, I already have it. So, my lord, may I formally praise it that it is maintainable. My lord, paragraph 88. That is at page 764.
Yes.
Now, this is reported in 2005, volume 4, Supreme Court cases 741. We are furthermore of the opinion that the jurisdiction of the High Court in entertaining a review application cannot be said to be ex facie bad in law. Section 114 of the Code empowers a court to review its order if the conditions precedent laid down therein are satisfied. The substantive provisions of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 of the Code, in terms whereof it is empowered to make such order as it thinks fit. Order 47, Rule 1 of the Code provides for filing of an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or where there exists an error apparent on the face of record, but also if the same is necessitated on account of some mistake or from any other sufficient reason. Thus, a mistake on the part of the court, which would include a mistake in the nature of undertaking, may also call for review of the order. An application for review would also be maintainable if there exists sufficient reason thereof. We would constitute sufficient reason would depend on the facts and circumstances of the case, and then sufficient reason is explained below. So, in my most humble submission, below, mistake of fact in my most, I should have, my lord, pointed out. I remember, my lord, that I had made the submission before your lordship that there is a judgment of Justice Moshu. It is my mistake. I should have, my lord, handed it up to your lordship. These are my humble submissions.
Yes.
Two things, my lord. Since my learned friend has submitted on the law, my lord. First, my lord, I will submit on law whether, my lord, this order of your lordship is at all, my lord, reviewable or not. Lord, what my learned friend is, my lord, seeking today is, my lord, the plain says they have made the payment by RTGS, my lord. And, my lord, we have indicated that he is involved in the business of money lending, and therefore your lordships, my lord, had passed an order, my lord, in our favor, dismissing their application. Today, my lord, at best, what my learned friend is argued is an argument that, lord, that the order is erroneous. And that, my lord, to that extent, my submission is that that can only be an appealable order, my lord, not for review, my lord.
and there are two distinctions, my lord. An error apparent on the face of it, and my lord, an order according to a party is erroneous. My lord, erroneous has always to be, my lord, corrected by the superior court, my lord. And my lord, I am carrying. He's referring a 2005 judgment, my lord. I am carrying a latter date judgment of 2022, my lord, where, my lord, the Supreme Court has said, my lord, the distinction, and my lord says that the error apparent, my lord, can be reviewed, but the erroneous order cannot be, my lord, reviewed. That is, my lord, I formally cite, my lord, that is 2020.
No, the erroneous order.
Yes, I'm coming to that.
Whether they have disclosed in the plaint, it is through the
He has relied on, my lord, page 48.
Correct.
That is the annexure, my lord, Axis Bank Limited application for transfer.
Correct.
The law says, my lord, if it is a negotiable instrument, then only the question of money lending will not come. My lord will see, my lord, the check he is referring has been given to Axis Bank, not to me. My lord, what has happened? Possibly they have given the check to Axis Bank, then the Axis Bank has credited it to their account and then transferred.
No, but it is not in the name of the bank.
Yes. Yes. My lord, see, my lord, come to the page 44. That is 48. Remit sum of rupees 10 lakh, my lord, 1 crore only to the account number such and such, as details given below. Check number 199684, dated at favoring Axis Bank Limited RTGS. My lord, it is favoring Sudha Kankare. It is, my lord, RTGS, and my lord, RTGS, Real Time Gross Transfer, doesn't cover under, my lord, the Negotiable Instrument Act. This is coming under PSS Act 2007.
You give the Negotiable Instrument Act.
My lord, RTGS ipso facto comes under the payments of security.
Yes, my lord, that doesn't come
But
under the negotiable
RTGS
instrument.
is stimulated by issuance of a check. It is clearly stated in that page.
What
it
he
is
is today
payment
arguing.
to the contrary. That is what was my submission.
Lord, in fact, the Reserve Bank has framed the guidelines which called Real-Time Gross Settlement Regulation 2013. Lord, that says, Lord, it is governed under the PSS Act, Payment of Settlements. So the question of negotiable act doesn't apply in a transfer of RTGS. End of the day, the payment was made through RTGS.
Yes.
So, my lord, the Negotiable Instrument Act would have come into force only if, my lord, the plaintiff, my lord, have directly handed over the check or directly issued the check for, my lord, credit in a normal circumstance. Then, my lord, only the physical instrument will come into the picture, and, my lord, Negotiable Instrument Act. Now, today it is an admitted position, my lord, the payment was made through RTGS. The moment RTGS, he admits, my lord, it takes out, my lord, the purview of Negotiable Instrument Act, my lord. And this is, my lord, as he has admitted, it is coming under Payments of Settlements Act 2007. So, my lord, the judgment which is referring, my lord, that the since it is used in check and the Negotiable Instrument Act will apply, my lord, doesn't really apply. On facts, he says he has given to, my lord, Axis Bank, and then made an RTGS transfer. RTGS transfer, my lord, I am carrying, my lord, since I have not filed, even RBI guidelines says, my lord, there is no remitter does not need to have any use of checks even.
Yes, only a request.
Yes, only a request. So, my lord, therefore, once, my lord, is an admitted position that RTGS has been made, so, my lord, the judgment doesn't apply, because it will, my lord, will see, my lord, Justice Bhattacharya's judgment only relates that since the check has been issued and check is governed under the Negotiable Instrument Act, therefore covered under, my lord, the Bengal Money Lenders Act will not apply, my lord. So, on facts, my lord, this doesn't, the argument, my lord, doesn't substitute.
Yes.
So, my lord, that is my submission on, my lord, the facts that this is on RTGS, my lord. RTGS no way connected with the NIE Act, and therefore, my lord, your lordship was right enough to, my lord, hold that the Bengal money lending license was required. And on law, my lord, what they are arguing today, my lord, is a question of, my lord, whether the judgment was erroneous or not. It's, my lord, could have been an appeal at best. Today, my lord, what it is in the garb of, my lord, review. What they are arguing is, my lord, a rehearing whether, my lord, its payment was made through, because when we have taken this plea in the reply, they never said, my lord, what he is arguing today, that is not there in the reply. This point was never taken. What he's doing today, my lord, is for the first time in the review. My lord, see, we have taken the specific plea with regard to, my lord, the my lord had quoted that in the order. If your lordships kindly come, my lord, page 156.
156
is volume 2, my lord, of the stay application. Paragraph 5, we have taken this plea, my lord. My lord, my lord has got 156. My lord, this is, my lord, the pleading we have taken. I further say that the suit filed by the plaintiff is for recovery of money alleged to have been paid on account of loan to the respondent, and the present application has been filed essentially seeking a judgment and decree upon admission to the tune of such and such, which comprises of principal amount purportedly given on loan and the interest thereon. I further say that the plaintiff is inter alia engaged in the business of money lending within the state of West Bengal and therefore comes within the purview of moneylender as defined under Section 213 of the Bengal Moneylenders Act 1940. The fact that the plaintiff is engaged in the business of money lending would be apparent from the fact that the plaintiff has instituted several proceedings before this court, different person or entity, and for recovery of money, details whereof given. Then I have given the details. And then say the number of suits involved in the plaintiff involving monetary financial matters, including money lent and advance, which suggests that the alleged and purported loan advance to the defendant for recovery of loan whereof has been sought for in the present suit is not in a single isolated instances of money lending. The aforesaid suits filed by the plaintiff and further conduct of the plaintiff would also suggest that the money lending activity of the plaintiff is systematic, regular, repetitive, and continuous one, and the same is being done by the plaintiff in order to generate revenue by way of interest. I further say that Section 13 of the Bengal Moneylenders Act 1940 says that no court shall pass a decree or order in favor of the moneylender for recovery of loan advance unless court is satisfied at the time of such loan there is a the money lending. He has dealt with in paragraph 5 in the reply at page 206 of the same volume, Milord.
Yes.
As it would appear as a matter of record, the allegations made in paragraph 4 and 5 of the said affidavit are denied, disputed. It stated that the deponent is duly authorized by the plaintiff, filed the petition and affidavit connected with the present suit, and an affidavit of competency has been filed in the appropriate department of the Honorable Court, thereby impairing the department to make and affirm the said petition to the present affidavit and present affidavit. It is denied that Nirmal Kumar Bingani has not been appointed by the plaintiff as his constituted attorney and is competent to affirm the said petition as alleged. It is further denied the defendant does not have any knowledge about the alleged transaction and payers made in the said petition are liable to be rejected as alleged. It is denied plaintiff is engaged in the business of money lending and the comes within the purview of provision of the Bengal Moneylenders Act alleged at all. It is stated that in fact the Act 1940 is not applicable in the present factual matrix and mode of transaction between parties. It is further stated that the plaintiff is not required to demonstrate any money lending license under Section 1940 to pursue the present suit and further the obtained decree in his favor appropriate stage. It is denied the suit is and the said cannot be proceeded. So, my lord, he into my specific allegations, my lord, he reply was an evasive. He doesn't at that time he doesn't say, my lord, in the plaint he has indicated that it has been paid through checks. But what is today he is arguing is never the pleading. And Milord, the second part is that the very foundation of his argument that it is covered under Milord the Negotiable Instrument Act, his belief of his own admissions, Milord, that it is covered under Milord the PSSS Act. Once Milord the Payments of Settlements Act come into the picture, Milord, Lord, the relevant judgment, Milord, what my learned friend shows your lordship is the paragraph 4, Milord, page 4, that where Milord Justice Bhattacharya has dealt with Milord the only Milord the big negotiable instrument act, vice versa, Milord Bengal's Money Lenders Act, and this court does not have any occasions to Milord deal with the PSS Act. May I just read, Milord? Internal page 3 of the judgment, I have considered the materials on record in the course of submission of null and counsel appearing for the parties. Before dealing with the factual constitution, the point of maintainability must be addressed. Section 13 of the Bengal's Moneylenders Act 1940 prohibits the court from passing a decree or in order in favor of the moneylender in a suit filed by a moneylender for a recovery of a loan advanced, unless the court is satisfied that the moneylenders have an effective license at the time of granting the loan or advancing any part thereof. The other part of Section 13 are not relevant at the purpose of this application. Section 212 of the State Act defines a loan as an advance whereon any monetary terms or kind made on condition repayment with the interest, and includes any transaction which is substance in loan but does not include an advance made on the basis of Negotiable Instrument Act as defined in the Negotiable Instrument Act, other than a promissory note as defined under Section 20 of the T. Under Section 13 of the Negotiable Instrument Act, negotiable instrument has been defined as a promissory note, bill of exchange, check payable either to the order or to the bearer. A conjoint reading of the provisions under the Moneylenders Act and Negotiable Instrument Act makes it evident that a loan advanced by way of a check within the definition of Negotiable Instrument Act will fall outside the purview of the loan under the Bengal Moneylenders Act, and hence Section 13 of the same act which bars a court from passing a decree in favor of a moneylender of the suit for recovery of loan advanced unless his court satisfied that he has a effective money license on the date on the advance was made. So, Milord, to bring it, he has to, Milord, prove that the money was given by way of a negotiable instrument, Milord. Here, Milord, and the negotiable instrument either, Milord, in order or bearer, Milord. Here, Milord, the negotiable instrument was issued to, Milord, the Axis Bank, who in turns were issued, and therefore, Milord, the very foundation of transfer was not through a negotiable instrument, and it was through, Milord, a RTGS, which is doesn't cover under this. And, Milord, to that extent, Milord, he said that the judgment was not considered, as I was relying upon, Milord, a Supreme Court judgment, that this review application itself will not be maintainable in view of the fact what is arguing is, Milord, Milord, the could have been argued in an appeal, not in review, Milord. I am formally referring, Milord, 2022-17 Supreme Court cases, 255, Milord, page 33. Paragraph 33. Right, Para 22, 17, 255.
Paragraph?
Para 33.
33?
Yes.
Yes.
Milord, the Supreme Court has, in earlier paragraphs, have taken note of the various judgments. Says, as can be seen from the above exposition of law, it has been consistently held by this court in several pronouncements that the court's jurisdiction of review is not the same as that of an appeal. A judgment can be open to review if there is a mistake on error apparent on the face of record, but an error that has to be detected by a process of reasoning cannot be described as an error apparent on the face of record or for the court to exercise its powers for review under Order 41, Rule 1 of CPC. In the guise of exercising the power of review, the court can correct a mistake, but not substitute the view taken earlier merely because there is a possibility of taking two views in a matter. A judgment may also be open to review when any new or important matter of evidence has emerged after passing of the judgment, subject to the condition that such evidence was not within the knowledge of the party seeking review or could be produced by it when the same order was made despite undertaking an exercise of due diligence. There is a clear distinction between an erroneous decision as against an error apparent on the face of record. An erroneous decision can be corrected by a superior court. However, an error apparent on the face of the record can only be corrected by the exercising review jurisdiction. Yet another circumstances referred to in Order 41 Rules 1 for reviewing the judgment has been described as for any other reasons. The said phrase has been explained to mean a reason sufficient on the grounds at least analogous to those specified in the rule. So, Milord, what today he is arguing, Milord, is Milord, could have been argued in an appeal court, not before your lordship in a review jurisdiction. That's my humble submission, Milord. This review should be discussed.
No, thank you. Yes.
Milord, I'm only handicapped. I'm not carrying the Payment Settlement Act, Milord.
Oh,
Milord, there is a copy.
I am carrying the regulation, not the act.
The Payment Settlement Act I wanted to show. May I, my lord, just read out and hand up. I only have it in my mobile phone. May I please read out, my lord? First and foremost, my lord, Payment Settlement Act does envisage the consequence as is under the Negotiable Instrument Act for dishonor. I have shown, my lord, that particular page from the plain, where if your lordship, my lord, kindly comes to that page once again. (48) is one such example. It reads, please remit a sum of proof in such and such to account number such and such as per details given below. Check number such and such favoring Axis Bank, RTGS favoring Sudha Kankaria is enclosed. Kindly comes to the next page. These instruments, my lord, are instruments which is initiated through a check. It is common parlance. You have to write the check, you have to write the name of the bearer, and you have to request the bank that please do it in real time. Means do it now. Because if I give you the check, then you will have to encash it. It may take some time. Now, my lord, the Negotiable Instrument Act.
No, but
yes.
RTGS, if you go to the bank for RTGS, the check is to be issued to the bank and not
in
to
the check,
party.
In the check, my lord, the name of the recipient of the money has to be there.
Only the account number and IFSC.
That is what is necessary.
No, that may be
An
necessary,
account,
but the name cannot be.
Lord, kindly see what is there. This is
Yes.
this is the bank form.
Yes, it is the RTGS after remittance of.
Yes.
After remittance you got it.
So kindly see,
Can
Lord,
you show
what
the
is
check?
the name?
Can you show the check?
Lord, check has already been there. Check has already been there.
Then if it is not there, how the court, how in the application under chapter 13 or order 12 rule 6, whatever it may be, court can interfere, court can go into that fact.
No, my bank statements are there.
That's
I'm not asking for
bank statement you stated that RTGS.
my case is RTGS.
Bank statement you RTGS.
Yes.
Correct. And this court has considered with regard to that. And they have taken the plea with regard to the section 13. And court held that yes, section 13, and they have quoted
because there is multiple transactions. That is your lordship's view. I cannot deny that.
Correct. That so this court has
fully
now your case. Now you have come with the review application with regard to this court has ignored with regard to the transaction with the check. So that's why if the check is covered under the judgment passed by her lordship, her ladyship,
yes,
so this court has mistaken of fact is there. So the review is there. Correct. Now you have brought the notice of this case, page 48.
Yes.
Page 48 said that remit an amount of 1 crore to account number so and so in favoring Axis Bank of India. So check is in the name of the Axis Bank.
Kindly come to 65. This is what the banks write, Millard, from time to time.
265?
No, only 65. Only 65. Or Millard, page, your lordship may also come to page 60. Here, Millard, the word changes. Please remit rupees 55 lakh to account number such and such as per details given below.
Favoring
number.
Favoring
Axis Bank. Favoring Sudha Kankaria.
Favoring Axis Bank.
Yes. And favoring Sudha Kankaria. Yes. And now, Millard, the name of Sudha Kankaria is, I only have to show your lordship that this transaction began through issuance of check. And check is a negotiable instrument. There is no doubt about that. There is no doubt about the conception
of not negotiable. 138.
Yes.
All cases under 138 will go.
People would be very happy. Very happy.
Not happy.
We would not be happy, but the ones for whom it is bouncing would be happy. Now, Millard, for Payment Settlement Act, if a submission is made that the judgment only considers about Negotiable Instrument Act, doesn't consider about Payment Settlement Act, in my most respectful submission.
What says? What says Payment Settlement Act?
Payment Settlement Act defines It defines, my lord. May I start with electronic fund transfer? This is electronic fund transfer. I only have to show that I have given an instruction, and the mode of instruction was check. Electronic fund transfer means any transfer of funds which is initiated by a person by way of instructions, authorizations, or orders to a bank to debit or credit an account maintained with that bank through electronic means, and includes point of sale transfers, automated teller machine transactions, direct deposit or withdrawal of funds, transfers initiated by telephone, internet, and card payment.
And
card
payment.
payment.
Yes.
So all these include,
Where is the
in my case,
where is the check?
Instructions.
Instruction.
This is, my lord, real-time gross transfer
That's why
initiated through the instruction of check.
You have given the instruction to the bank. Please transfer this amount. I am giving the check in your favor, and you can transfer the electronics to the by means of the electronic to the defendant. So it has been checked.
So the moment there is check, check need not be, my lord, addressed to a person. So his bank account is there.
Maybe.
And that is the instruction, my lord, in my most humble
Okay,
submission.
give the
my lord.
payment on the act you give me. I will interpret that.
My lord,
I
this
will
requires,
interpret that whether
requires
there's a
interpretation. I'll give a copy, my lord. My lord, further it says, gross settlement system means a payment system in which each settlement of funds or securities occur on the basis of separate or individual instructions. I am only trying to, my lord, my attempt is to make your lordship appreciate the fact that my instructions was through check, and that is all that is necessary.
See, what judgment you have relied upon, Justice Bhattacharya judgment, it is, court has categorically held that if it is through the negotiable.
Yes.
Negotiable, okay, negotiable instrument.
Yes.
Negotiable instrument. If the negotiable instrument, whether the RTGS is coming under the purview of the Negotiable Instrument Act and under the definition of the Negotiable Instrument Act.
Under section 13, my lord, it reads that negotiable instrument shall mean promissory note, bill of exchange, and
check.
Now, my lord, if check is a negotiable instrument,
correct,
and if check is used as a mode of instruction,
correct,
for electronic fund transfer,
correct,
then, my lord, check is absolutely envisaged under the Payment Securities Act.
correct.
Because without that instruction, Payment Security Act cannot function.
So then you have to make the bank also. Then you have to make a bank also.
Bank is not the person from whom I am claiming.
So that's why in favor of bank, RTGS NFT favoring so and so so and so. You have giving the check to the bank with the request to transfer this fund to so and so so and so. Because why the bank you have been given the request? The bank cannot, either you have to write a letter to the bank, sir, I am having so and so account, so and so, and this amount is to be transferred in the account number so and so by way of RTGS, whatever the fee, I am ready to pay that. Or it may be deducted from my account. Or you enclose the check, please remit this amount to, I am favoring the check to you, and this amount may be transferred. So in future, the bank cannot be blamed that how the amount has been transferred. So this is a security of the bank. This is the security
protection
of the
for the
bank.
bank.
Otherwise, why you have not issued the said check directly to the plaintiff?
Only
and
for the
directly
reason
to
that I
defendant?
wanted it to be in real time.
Huh?
In real time.
Real time.
That means I am giving the check and
Immediately.
immediately. Lord, may I come back any day for 15 to 20 minutes with a hard copy of this act?
Come.
Any day.
Come with the RBI guidelines also.
Oh, yes, my lord.
Then
I
it
would
has
definitely,
to
if my learned friend discusses it with me, I will definitely.
No,
my lord. This
because-
is the point, my lord. I had discussed, my lord, of the record, my lord, Mr. Dotto had appeared, Mr. Dutt. So, my lord, in another matter also, where Mr. Dutt is leading me, we were having this query. But, my lord, I also came up with the point that it is not so easily relatable, because both are different acts. If your lordship gives me one opportunity, I would try to, my lord,
Yes,
show
come.
how they may be
This is
similar.
the law point. You can argue that. the point of law?
Any day, if your lordship, a week's time, and I will come back before. And in the meantime, I'll also check up the RBI guidelines, because negotiable instrument, there is a judgment, my lord, that with respect to
That's
negotiable
okay, because
instrument, no money
negotiable
lender.
instrument, three
If it
things
is
has been
RTGS,
defined.
then it may. And if it is-
Negotiable has been defined three things
yes,
under this act, section 13.
yes.
Correct. So now if you want to treat as a negotiable, because the judgment which you relied upon, her ladyship has relying upon, if it is a negotiable
And facts
instrument,
was checks. Facts were
that's why.
checks, not RTGS.
Facts were checked, but
Yes.
yeah, her ladyship's contention was if it is a negotiable.
Negotiable instrument.
So RTGS is whether a negotiable
That is what I
instrument
have to,
or not.
uh,
If it is a
find out.
negotiable instrument, then you are in,
Covered.
or you are now it is not the negotiable, then you will be out. That is the thing.
Yes. My lord, may I come back any time? It is suitable to your lordship.
So,
In fact, the RBI has dealt it with a non-negotiable instrument.
that's why
Yes,
because I have dealt with
Yes.
the judgment, because I have dealt with the case with regard to the
But I have
RTGS.
got it from it's RBI website itself, where they have said that it is not a negotiable instrument.
No, my lord, what it confuses is this act in section 25 of this act says that if there is a default, then punitive action is similar to that of negotiable instrument. It is stated. I would like to, my lord, elaborate a little more.
Punitive like to the negotiable, but not under the 138.
No, may not be under the 138.
Under what section? Because
Yes.
punishable under only 138. If it is a 138, punishable under 138, then only the check and the dishonor.
That is what is, my lord, making me think that it may be.
As a different
Let us, my lord,
Can't be.
let me find out a little more. I must.
Suffering for the plaintiff, suffering for the defendant. The plaintiff has filed the present application, being review number 24 of 2024, praying for review of the odd judgment passed by this court dated 24/4/2024. Both the parties have argued at length. Police of counsel for the plaintiff prays for time to take further instruction and to argue the matter further. Accordingly, case adjourned. Let the matter appear on when?
Lord, the first week of May, my learned advocate on record is not there next week.
Let the matter appear on 7th May.
Lord, any time?
It will come on Friday.
Anything.
Friday.
Oh, yes, non-commercial.
16th May.
16th.
No, 16th, I'm in some difficulty. my lord.
Then what?
16th, my lord.
Second is having other matters.
No, Friday করে আসে, Friday করে আসে.
Every Friday it will be taken. 16 or 23?
23, my lord, is কি করে যাবে?
16 or 23 any day.
The second, sometime, my lord, 15.
Second already other matter. This they have mentioned the argument is going on with regard to the testamentary matter.
16th only, 9th is a holiday.
No, 9th is a holiday. Then the 16th on
16th and 23rd, my lord, difficult.
These are the two.
Any other day. I won't take more than 20 minutes.
No, I can't fix because other matters are fixed. My commercial matters are fixed.
Then let us come back after vacation. There is all I can say. I was hearing that your lordship may be in some difficulty
That
in passing
maybe
orders.
the circuit may be there.
Yes, yes. But then let us, my lord, come back in the first week of June. That is 13th of.
Come on 13th June. 13th June at the top.
I'm deeply obliged.
Yes. Next.
Lord, my lord, I beg to appear on behalf of the plaintiff. My lord.
Item number?
My lord.
16. Yes.
My lord, GA3 is my application for amendment. Your lordship kindly
Who is for the defendant?
My lord, defendant appeared. My lord, Mrs. Noel Banerjee was appearing. My lord, they did not appear on 4th April when your lordship was pleased to record that in the event they do not appear, the matter shall be taken up.
Yes. Where is the application?
My lord, GA3 is my application.
Where is the amendment?
Yes. My lord.
What amendment you sought?
Yes, I'll quickly indicate to your lordship. My lord, there was a mathematical error in the calculation to the schedules that we had, my lord, annexed to the plaint. We had moved the, my lord, interlocutory application for injunction. Then your lordship had pointed out that, my lord, there is some mistake because the figures are not tallying. If your lordship kindly takes 2 pages, my lord, page 50.
50?
Yes, your lordship. This is an annexure to the original plaint that I had filed. My lord, page 50, and your lordship will kindly take page 93. I'm sorry, my lord, kindly takes page 91, page 50 and page 91.
Yes.
Yes, your lordship will see that the total at page 50 is 298,13,326, and that at page 91 is 298,37,999. So, my lord, the fourth entry from the top, which is a debit note at page 91, my lord, a sum of rupees 24,763. My lord, this was not taken into account in the original schedule that we had filed. My lord, the figures matched, but from the schedules, my lord, we were not in a position to come to that figure. So there were some excess payments made, on account of which, my lord, we had refunded, and a debit note was, my lord,
So,
lordship.
2 crore 98 lakh 13,236
Yes.
plus 24 lakh 24,763. What would be the total?
It's coming to 24,763, which is the fourth entry at page 91.
Two crore 98 37 999.
This is the exact same amount, which, my lord, we could not.
Next.
Yes. My lord, page 53 is a schedule showing the amounts due, which was also incorrect because, my lord, this entry was incorrect.
53?
My lord, 53 is the original schedule that we had prepared. My lord, on account of this entry being incorrect, my lord, the calculation here is also incorrect. So I have prayed for leave, my lord, to amend both the schedules to the plaint. And, my lord, I have an additional prayer.
So how the 53 can be incorrect?
Lordship,
53 is a different.
Lordship, I'll show. 53 is different.
Yes.
Yes. Now, my lord, if your lordship kindly takes the plaint for once. Lord, there were certain part payments made. Your lordship kindly takes page 39. My lord, this is what should have been due. 1782,319.
Aggregate 17,82,390.
Yes, my lord, we were not in a position to come to this calculation, which is why your lordship had adjourned the matter and directed us to take, my lord, instructions. My lord, there are certain part payments made, which is why the schedule at page 53 is incorrect. My lord, there were part payments made, which I have pleaded in my plaint. My lord, kindly sees from paragraph 8 onwards, I have pleaded that there have been part payments made. So after taking into account the part payments, my lord, my correct schedule is at page 93.
So that's why first you show me what is your schedule of amendment? Where is that?
Lordship.
What amendment you want to?
Lordship, I'll show. My lord, the amended plaint is.
Where is the proposed amendment?
My lord, page 94 it starts.
Yes. Where is the amendment? First amendment.
My lord, page 96, paragraph 6.
Page 96.
Yes, your lordship.
Paragraph 6.
Yes.
And what is the paragraph 6 of the main?
My lord, the additions are underlined at page 96.
Upon such so, if necessary, that the apart from the plaintiff had issued debit notes of so.
My lord, at paragraph 7,
okay.
The schedule was wrong. We have striked it out.
Then 98 and paragraph 7.
Yes, your lordship. We have striked it out since the part payments were not taken into consideration. And my lord, at paragraph 19, I have shown the sums due at page 101. And 101 paragraph 19, my lord, will tally with the revised schedule at 93.
Then,
My lord, I have prayed for leave.
so these are the two.
My lord, two. My lord, additionally, I have prayed for leave before your lordship to disclose an additional document, my lord. My lord, I have explained in my application, if your lordship takes, my lord, the person concerned who was looking
That cannot be.
My lord?
That cannot be. How the additional document can be allowed
My
after
lord,
filing of the suit?
yes, yes.
Plaint.
Your lordship, I'll try to address your lordship on this. Perhaps I'm covered by your lordship's judgment in Glen Industries, my lord. Your lordship had passed a judgment, my lord, allowing my lord disclosure of additional documents which were not filed on account of miscommunication between the parties, and thereafter your lordship had allowed the document to be, my lord, disclosed in view of the fact that, my lord,
Now, if you
the
want
suit had not progressed. The suit had not progressed to a stage of trial.
Show me.
Yes, your lordship. My lord, taking note of the judgment in Sudhir Kumar, your lordship passed this judgment. My lord, I shall not.
When you file the suit? When you file the suit?
My lord, I'll indicate.
Yes, part was allowed, part was not allowed.
Yes.
Whether because that was not in possession of the plaintiff. So where, what is your
Yes, my lord, I'll show your lordship my case. My lord, the person.
which document you want to include?
Yes, your lordship, I'll show. It is a debit note.
Debit note.
Yes.
So debit note automatically it will with you.
Yes, my lord, I have made out a case.
In your possession.
Your lordship will see I have made out a case that the concerned person who is to look into the accounts, he knew about the debit note. My lord, he was not there at the time of filing of the.
No, I will not allow with regard to the new documents, sir. Sorry, which is in your possession, I will not.
My lord, your lordship will kindly see whether I have disclosed.
Sorry.
My lord, reasonable cause I have shown.
Panic, go to the act itself. Order 11, Rule 6.
Yes, your lordship, there are three situations. I have to file with the plaint. In case of urgent filing, 30 days.
Correct.
And thereafter, upon showing reasonable cause.
Reasonable cause.
Yes.
Reasonable cause. What is the reasonable? Give the Commercial Code Act.
Yes.
It was not in possession of the plaintiff or in possession of the defendant.
Lordship. Lordship. Yes. Your lordship kindly sees my pleadings once, my lord.
That's why I'm asking what is
Yes, yes, my lord, the concerned person who used to look into the account of the maintained
other accounts with you. Only the one debit note is with the other person.
No, he's an employee, my lord.
It is believable.
My lord, he's an employee of. Sorry. He's an employee of mine, my lord. My lord, I have also disclosed a prescription, my lord, showing that he was.
This type of the practice I will not allow. Kindly come to the order 11. The plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody, and not disclosed along with the plaint or within the extended period, save and except by leave of the court. Such leave shall be granted only upon the plaintiff establishing reasonable and cause for non-disclosure. So, what is the reason of
your lordship? Kindly takes page 4, my lord.
Which page?
My lord, of my application. My lord, page 5, your lordship comes to at paragraph 11. My lord, I have stated at the time of filing of the plaint, Dinesh Kumar Mishra, associated with the plaintiff, could not attend to his official duties. My lord, account was supervised by him. He was not there. My lord, I have annexed a prescription.
This is an employee. Employee is not carrying all the document with him. It is you.
My lord, it was there in the office. My lord, it could not be traced out.
Other documents are there. How the court?
My lord, this is why we had missed this entry, my lord.
Sorry. If you want to allow, I will allow other part of the amendment. I will not allow this.
Very well, your lordship. Your lordship allows me to amend the plaint, my lord.
I will allow only with regard to the which portion? Paragraph 6 and 7. Paragraph page 96, 97, and 98. Not with regard to this paragraph 19.
Lordship, this is the schedule, my lord. At paragraph 19, my lord, this is the schedule.
But annexer K? What is the annexer K? Letter K?
That is the schedule. My lord, the debit note is a separate annexer.
So which document? Where the document you mentioned?
My lord, page 5.
In your proposed amendment, where is the document you mentioned?
My lord, the debit note I have mentioned at page 98.
Ah, that's why that I will not allow. D.
D.
What was the earlier D? Where is your earlier D?
Lordship, this is at page 37, my lord. Lord, these are two outstanding invoices. Page 37, paragraph 7.
Copy of the bank statement voucher. Where is the next D? Which page?
My lord, to the original plane is at page 37.
Page?
37. Paragraph 7.
Where is the document?
Oh.
Which document?
My lord, this is page 54 and 55. These are the invoices that we had, my lord, already. We had.
54.
Yes.
Was the D?
Yes.
Earlier it was D.
Yes.
So, how you can change this? And where is this document? Page 98, which now you went Annex D, which you want to include here.
My lord, the invoices now are at page 115.
116.
116 is, my lord, that debit note which we are praying for leave before your lordship to disclose.
So where is earlier? What will happen to the earlier D?
My lord, now after the plaint being amended, my lord, if your lordship permits us to amend the plaint, then my lord, the plaint which is annexed as X, my lord, this will become the plaint.
So what will happen to this? Page. What will happen to the page 54?
My lord, the invoices. My lord, they are already there. My lord, I'll show your lordship. My lord, they are now annexed as C at page 114. 114, 115, my lord. They are there.
Yes. So I will not allow this. 116 I will not allow.
My lord, suit has, my lord, only summons have been served. My
Maybe.
lord. It has not proceeded.
It is the court and the plaintiff. The court has to see whether the new document is to be introduced after the presentation of the plaint. You have presented the plaint.
Yes, yes.
Presentation is over.
Yes, yes.
Then,
yes,
after the presentation of the plaint, how the new document can be allowed to you bring on record under the Commercial Court Act?
No, my
which
lord,
is in your possession.
My lord, only upon your lordship granting leave, my lord.
That's I am not granting leave. This I suspect this document. It is your seal, your signature. Correct?
Lordship.
Page 116 is your document.
Yes, your
It is your seal.
Yes,
your signature. Where is the receipt signature? Where is the signature of the defendant receipt? You're telling that this is a debit note. Debit note might have been signed by the defendant.
Lordship should have.
Where is the signature? Sir, I was there for 25 years. More than. I dealt with many advocates on my opposite side.
Yes, this is my document. My lord.
Then, now your document. If how you can say it is genuine? If it is a debit note, you could have been given to the defendant. Defendant could have been received. the amount has to be deducted.
My lord, we gave it to them.
So where is the receive copy? This is not the mail copy. This is not the mail copy. Tell me how much cost? You decide how much cost.
Your lordship doesn't, my lord, impose costs.
Making fool to the court, you have to bear some.
No, my lord, that was never the
50 lakh.
It was never our intention, my lord. I apologize. As instructed.
That's why you have been sent. I know who is behind you.
No, your lordship, I had drafted the application, my lord.
I know, sir.
This has come to the note, my lord, which is why, my lord, we have.
You show me with this is a genuine document.
My lord, original nahi aasta.
How you can prove this is a debit note received by the defendant?
Lord, may I try to come back with the original?
Sorry.
Lord, thereafter, my lord, they have, my lord, issued balance confirmations, my lord. Everything is
Maybe balance confirmation. So why you have introduced this document, which is not having the signature of the defendant?
Lord, in aid of that entry, my lord, we thought, my lord, we should disclose a document.
Shall I dismiss?
Your lordship, my lord, permits the amendment to be carried out, my lord.
No, I will not allow the amendment also. Now the faith has gone. I was supposed to allow the amendment, but the conduct is not good. So I will also not allow the amendment. I will record all these things and impose cost also. So it will be better to you to get the order from the appellate court.
No, your lordship, it was never our intention to, my lord, come before your lordship with unclean.
So why you have come with the unclean hand?
It should have been checked, my lord, that it's a receipt.
Amendment without check. The court can appreciate the plaintiff has filed in a very hasty manner. So you could not check, but the amendment cannot. One person cannot say that it is without check. You file the document with the knowledge you file the document in the amendment, and you wanted to introduce by way of amendment. So and suffering for the plaintiff.
My lord, kindly allows us to amend the plaintiff.
On behalf of the defendant. The matter was listed on 4th of April 2025. On the said date, also none appears on behalf of the defendant. But for the interest of justice, the case was adjourned. And in the order dated 4th April 2025, it was categorically mentioned that on the date fixed, if the defendant does not appear, the application filed by the plaintiff will be taken up for hearing in the absence of the defendant. Full list. The plaintiff has filed the present application praying for amendment in the plaint as well as filing additional document. This court find that the plaintiff has made out a new case in the plaint that the plaintiff had issued a debit note to the defendant on account of excess payment made by the defendant at that juncture. Full stop. A sum of rupees 24,763 was refunded to the defendant by the plaintiff. Initially, when the plaintiff has filed the suit, the said amount is neither reflected in the list of invoices, nor the schedule, nor in the schedule. Now, by way of amendment, comma, the plaintiff intend to bring one document. Where is the page? Bring the document which is appearing at page number
116, my lord, is the debit note.
It is appearing at page number 116. 116 as debit note, but this court find that the said debit note is of dated 30th September 2019, but it has neither been signed by the plaintiff, nor by the defendant, nor the person who has prepared the said document.
Lord, the plaintiff perhaps had signed, my lord, with the stamp.
It is found that only the said document having the stamp of the plaintiff company with one initial, but this document is not shown that has been received by the defendant. Received by the defendant. The plaintiff has filed a suit, and the same was presented before this court, and the same was and after the admission, comma, the plaintiff has after the admission of the plaintiff, and at the time of scrutiny, when the department has pointed out the defects, comma, the plaintiff has filed the present application for amendment along with the prayer for additional document. This court find that the document which the plaintiff has relied upon and plaintiff intend to bring on record is of 30th September 2019. That is before the filing of the plaint, and it reveals that which proves that the said documents with the hand is in possession of the plaintiff, but the plaintiff has not given any justification why the plaintiff has not disclosed the said. In paragraph
11 onwards at page 5.
In paragraph 11 of the present application, the plaintiff has only mentioned that one Mr. Dinesh Mishra associated with the plaintiff could not attend his official duties on account of reasons beyond his control, and the account was maintained by the said person, and as such, the said document could not be produced at the time of filing of the present application. The statement made by the plaintiff could not be believed, as the plaintiff has relied upon several documents which are connected with the accounts of the plaintiff. Only one document, it cannot be proved that one Mr. Dinesh Sharma was having the said document. Considering the above, this court find that only to bring some additional document, comma, the plaintiff has come with an application for amendment, which is not permissible under law. Accordingly, the application is dismissed. This is the second time before this court by sir, you?
My lord.
This is the second time he has come that this type of the work.
My lord, I had earlier not moved any such application. I apologize. My lord.
In item number 17, my lord, was clear, my lord. The other side is here, my lord.
Undefended.
Undefended suit, my lord. Only, my lord, the direction for judge's brief of filing of judge's brief of.
No, my lord, I have filed an application, my lord.
Undefended, not served.
No, it was not. Your lordship had indicated on the last occasion that if I wanted to file, I can file an application by today.
Okay, so what you
Then
want
I
is
have
the undefended. Come tomorrow with the evidence. I will take the evidence.
My application is there, my lord.
You may file an application that will be decided after the decree.
No, my lord, your lordship, I'll just refresh, my lord, my learned friend's memory also of what.
For filing judge's
Sir, let my fixed matter may be taken.
Very well, my lord.
Yes, call the fixed.
My lord, may I file the judge's.
No, my lord, this is my lord.
No, I am not accepting.
But undefended now, my lord, they are standing
all
in the wheels,
my lord.
coming one after another.
Come with the evidence tomorrow. I will take evidence. I am telling in the open court.
Call with the evidence tomorrow.
Because on the last occasion, your lordship had
Evidence will be
indicated
taken.
that I was at liberty to file the application. This is not,
Liberty
my lord.
court cannot curtail, sir. You can file an application. When the application will come, the court will decide. But the court cannot sit tight over the matter. Yes, you will file an application. This will be decided, and you will be allowed.
No,
Now, as on that, it is a fix for undefended suit. If you wanted to adduce the evidence, come with an evidence.
Lordship indicated your lordship was giving a longer date so that.
Yes, I have given a longer date, but you have not used that.
No, I have. It's GA2, my lord.
But it is not listed. Neither you mentioned.
June 24, writ of summons, sir.
You have filed. You have not mentioned the matter. Let the matter come. You have not mentioned. Now it is the suit is undefended. So let come.
Your lordship was pleased to observe, my lord, that
I am not telling. I have not observed. That's why I have fixed the date. But you have not used that time. Call the matter.
Item number 5. Then, my lord, kindly give one direction that the item number 17 will no further be called today. But we have.
No, I don't think it's going to be called
know.
anyway.
I don't know if the matter will be adjourned. It will be taken.
Throughout the day, we had waited, my lord.
I don't think because this matter will come and 3:45
It may be dismissed for default, my lord, if it is.
Okay.
Must see their conduct.
Okay.
But I'll keep it in mind, my lord. And let it go. Take the one. Number 5.
Next matter. Lord, may I please your lordship? Lord, it's today. Lord, I was submitting before lordships the issue number 3, and the issue number 3 was partly dealt with by me, my lord. And there, my lord, in discussion, my lord, I was placing before your lordship the letter dated 31st January 2011, and that is the letter from Chief Bridge.
That is the approval letter.
Approval letter.
Yes.
Approval letter I presented before lordship, and that approval letter was duly communicated, my lord, by the deputy chief engineer. That letter is there. Then, my lord, I will come. I will not repeat, my lord, to save the time of the honorable court, my lord. Then, my lord, plaintiffs did not follow the instruction given in that approval letter, which resulted their failure to complete the project successfully, even after extending the completion period till 31st March 2014. As a result thereof, defendant railway had to suffer huge financial loss as well as loss of traffic to carry the freight and passenger, because this was for the third line. This state, Chhattisgarh state, is having the lot of minerals, and to carry the minerals to other part of the country, it's required some additional line. For this purpose, to freight and passengers to make additional line, so work delayed. Therefore, the railway had suffered, due to the passengers and freight in both.
You have a counterclaim.
My lord,
you have filed a counterclaim in this matter. Have you filed the counterclaim in the suit?
Counterclaim, yes, my lord, I have. I have filed.
So, with regard to the damage which you have not
Here that is mentioned.
What is the document? How you prove that damages?
I will come, my lord. I will come, my lord. That is serially I am coming, my lord. After the completing this, my lord, the plaint, I will come to my counterclaim, my lord. Because, my lord, I do little, my lord, in suit matters. Therefore, this is maybe the something which we are missing, my lord, from my side. Kindly excuse me for that, my lord. My lord, the said subsoil exploration report, being Exhibit 2, which I placed before lordship, clearly indicate the presence of hard rock, and to penetrate the hard rock, the provision of control blasting and use of explosive have been provided in Chapter 12, Clause 5.1 and 7.1 of the Special Conditions of Contract. Then, my lord, the plaintiff, in reply to 7 days notice, dated 30th of January 2014, being Exhibit 11, the plaintiff for the first time raised objection, while their reply dated 14/2/2014, being Exhibit NN to subsoil exploration report of the Vision Labs and suggested two options to inter alia. What option suggested, my lord? I am placing the exhibit NN.
With the exhibit NN.
You know, this letter is given in reply to the 7 days notice from the plaintiffs. And the plaintiffs, my lord, stating here, request for closure of contract dated 2/9/2011 or acceptance letter dated 28 July 2010 without liability on other side as per clause 61. GCC is in connection with the work for construction of foundation, substructure, approaches, including allied and miscellaneous works for major bridge number 182 between Eve and Brajraj Nagar station in connection with third line between Chapa Dharsugra. So instead of completing the work, the plaintiff is writing letter to closure of the contract. And here, my lord, without reading the entire letter, my lord, I am coming to the, my lord, what the plaintiff stated at the last of the letter. That is at page 42. It is stated that in view of 42? The above, we earnestly request. Page 42? No, here, my lord, this is the documents. This is the plaintiff's document. This is the internal, my lord. Internal. This is the page third.
Third page. Yes.
Third page. My lord, here, my lord, here request for closure of contract, and what the plaintiff suggesting that in case of option one, first is review and revise the minimum socketing required in hard rock as per IRC provisions to 300 mm, 600 mm section NS term well sinking in hard rock of work already executed as well executed further based on joint NLC set side. And second, in case option 1 is not acceptable to railway, considering aforesaid situation, the contract may kindly be closed without any liability either side under force majeure clause as per the clause number 61 GCC. Outstanding dues deposit be refunded. So this what the plaintiff not completing the project, rather interested in closing of the contract and suggesting that close without any liability. So railway cannot accept this because railway by this time already paid about 7 crores to the plaintiffs. So, my lord, this suggesting that this should be treated as the force measures. And my lord, the force measures have been dealt with
Yes.
my lord, plaintiff suggesting the contract may be closed under clause 61 of the GCC as the force measures. Then, my lord, force measures has been defined in GCC. That is, my lord, force measure has been defined in GCC at clause 17. What are the, my lord, situation which will be treated force measures?
Clause?
What are the situations? Clause 17 of GCC.
Yes.
My lord, may I read to, my lord, GCC, মানে contract paper the মধ্যে GCC পাবে. That is the G.
कल वो था ना बाइंडिंग वाला.
Yes. Clause 17.
Yes.
Force majeure clause. This is suggested by the plaintiffs to close under this clause. And what this clause says, if at any time during the continuation of this contract, the performance in whole or in part by either party of any obligation under this contract shall be prevented or delayed by reason of any war. War. This is not a condition of war. Hostility. No hostility. Acts of public enemy. That is not there. Civil commotion. Not there. Sabotage. Not there. Serious loss or damage by fire. Explosions. Epidemics. Strikes. Lockouts. Or acts of God. That's all. These are the events when it can be the force measures clause will apply. Otherwise not. So here, my lord, none is applicable except my learned friend has taken the plea of flood. That I will come later on, my lord. I will come later on. So, my lord, my submission is this, my lord.
So the flood will come act of God.
Natural calamity has been stated, my lord, but that should be declared by the state government. Natural calamity should be declared by the state government, and my lord, there is no such declaration. And my lord, it is a regular phenomenon. Each and every year there will be heavy rainfall, and some part of the flood will be there for limited period. But that will not frustrate the entire contract. Therefore, my lord, this I submitted before lordship. Force majeure clause will not be applicable for closure of this contract. My lord, I place before lordship that in question number 68, the defendant railway witness number 1 answer has stated that defendant number 3 in its letter dated 16/6/2011 exhibit 14 to the plaintiffs referred that 4 months after approval of drawings, no detailed work program was planned and resources mobilization program was submitted by the plaintiffs. This is I am showing to delay. My lord, this is specific. There is a letter, my lord.
What is the letter?
That is the letter.
Exhibit?
16/6/2011.
Exhibit
14.
14.
14. 1/4, my lord.
Of your?
This is my letter, my lord.
Issued by the plaintiff?
Issued by the defendant, my lord. Issued by the defendant number 3, Deputy Chief Engineer. Recording that 4 months already elapsed and no progress. That is the paragraph 5, my lord. It is regretted. Has you also got it?
Yes.
Paragraph 5 of this letter, my lord. It is regretted that despite many instructions, till no works program submitted, it is once again advised to submit your detailed work program, which with proposed resource mobilization for completion of subject work, set up the laboratory, communication at work site, and submit the required documents of your site engineer for proper monitoring and progress of the workplace. So this is, my lord, the letter from the railway where it is shown, my lord, there is no proper, my lord, interest taken by the plaintiff to carry out the project, and they delayed even after the, my lord, the approval of drawings.
This is the letter issued by you on 6/6/2011.
16/6/2011.
Correct.
Yes,
16/6/2011.
Yes.
So, and they have foreclosed the work on 14 February 2014.
14.
What has happened in between?
That is the subsequent, the closure of the contract letter is subsequent. And before that, I am showing here, my lord, the delay in execution.
That's why I'm telling, with regard to this is the first letter you issued on 16/6. With regard to the delay of work by the contractor.
There are several letters, my lord, but this is the one of them. Correct. One of them. Correct. My lord. This is one of them where it's pointed out that already 4 months already elapsed, but there is no progress after the approval of the drawings. After the approval of the drawings and designs, the plaintiffs is not progressing in works, and that time stated there that already 4 months already elapsed, but there is no progress. So this is just not this letter that there is delay on the part of the plaintiff to carry out the work. The subsoil exploration report prepared by the Vision Labs Hyderabad, being Exhibit 2 at page, the report has clearly mentioned about the hard rock down the bed river at abutment 1 after 7.5 meters from the top, presence of hard rock zone. Similarly, Pier 1, Pier 2, Pier 3, Pier 4, Pier 5, Pier 6, Pier 7, presence of hard rock zone in the river bed is shown in the chart annexed in the subsoil exploration, already shown before your lordship. Study. Then issue number 4. Issue number 4, my lord. If the answer to the previous issue be in the negative, whether the supervening and intervening circumstances, including the work methodology approved by the defendant number 2, render the contract unworkable and unfeasible in terms of the contract conditions. The answer to this issue, my lord, the defendant railway submits that the alleged supervening and intervening circumstances and the design drawings and work methodology approved by the defendant number 2 on the basis of the subsoil exploration report and GAD made over by the defendant number 2 will not frustrate the contract and render it impossible of performance of the contract for the following reasons. 1, my lord, the law and order. My lord, here stated that there was insurgency. My lord, here, my lord, the answer to this, my lord, the law and order is the state subject, and railway is not responsible for maintaining law and order. However, after lodging FIR with local police, the working environment created and work resumed in the month of June 2011. Further, on 29 September 2012 to 29 May 2013, similar incidents reported by the plaintiffs. And to facilitate smooth working at the site, defendant railway had requested Chief Security Commissioner RPF Southeast Central Railway Bilaspur to take necessary action. Accordingly, the said authority of the defendant railway took necessary action. About 4 persons were arrested by the local police, and thereafter there was no such incident of threats and antisocial activities which occurred at the worksite. Then 2, my lord, the plaintiff have alleged obstruction by flood being a natural calamity during construction period. The defendant railway submits that it has not found any declaration of natural calamity of flood by the state authorities during the contract period. Further, in the rainy season, rains are inevitable, and as a result, risk of increase of water level of the river is also inevitable. But the said problem is for limited period of time and cannot be an excuse for non-completion of the said project. Third, my lord, by letter dated 6/3/2014 from the defendant railway being Exhibit S to the plaintiff, the aforesaid issue have already been described by the defendant railway. Further, the plaintiff have received about 6.7 crores rupees through running account bill submitted to the defendant railway. My lord, I place the Exhibit S.
Exhibit S, though. S.
Exhibit S. Lord, this is the letter.
Yes.
Lord, this is the letter, my lord, which was written by the railway, my lord, on 6/3/2014. And here, my lord, the suit was already filed on 4th March 2014. But there was no information of filing suit by that time. And before that, the plaintiff had written a letter dated 14th of February 2014. So this was the reply to that. So here, my lord, what the railway has stated, my lord, your request for closure of contract agreement dated 2/9/2011 in connection with work construction of foundation substructure approaches including allied and miscellaneous works of major bridge between Eve and Brajraj station in connection third line between Chapa and Jharsuguda. The works was awarded to you. Has you also got it?
Yes, yes, I am.
The works was awarded to you by wide letter of acceptance at reference 1 at cost of 12.30 crores with target date of completion on 27/10/2012. Subsequently, extension of time has been granted up to 30th of August 2013 under clause 17A with price variation clause and up to 31st March 2014 without price variation clause. But progress of work did not improve in spite of repeated instruction wide letter dated such and such. It is worth to mention that wide letter at reference third, you had given commitment in the form of bar chart, but progress remained very slow. Therefore, a 7 days notice served wide later at reference 7, but progress did not improve further in spite of issuing 7 days notice. Negligible progress achieved, hence 48-hour notice issued wide later at reference such and such. Progress did not improve. Then, my lord, the letter of acceptance issued on 28/7/2010, but the first incident of vandalism at work site occurred on 1st January 2011. The structural drawings of well foundation approved on 1st/2/2011. It is worth to mention that law and order is a state subject and railway is not responsible for maintaining law and order. However, after lodging FIR with local police, the working environment created and work resumed in the month of June 2011. Although similar incident of threatening and antisocial activities occurred on 29/9/12 and 29/5/13 to facilitate smooth working at the site, undersigned had requested Chief Security Commissioner RPF Bilaspur to take necessary action. Accordingly, Chief Security Commissioner RPF wide his letter dated 21/10/13 intimated that 4 persons has been arrested and by local police in connection with incident on 29/5/13. Moreover, during interrogation, they accepted involvement in the incident dated 29/9/2012. The railway administration has coordinated with GRP and local police for better working environment. Thereafter, no incident of threatening or antisocial activities were occurred after 29/5/13 to till date, but agency had failed to improve the progress of work miserably. Whereas railway administration made sincere effort to ensure better working atmosphere. Since soil investigation had already carried out for bridge 182 before awarding of the contract and to avoid infructuous expenditure and save time, railway has advised you to do not carry out soil investigation. However, design of well foundation submitted by agency and after approval of structural drawings on 1/2/2012, you had accepted the design as no objection raised at that time. Moreover, work started and a total payment of rupees 6 crores has been already received by you without any dispute with regard to hard rock strata. During the sinking of well of abutment 1, the soil strata actually found at site is matching with the soil investigation report. That is, no hard rock is found and only black coal is found. Since hard rock strata are actually not available, hence question of founding at higher level does not arise. Hence, reason explained by you is not acceptable. It is again reiterated that during the sinking of wells for abatement 1 and Pier 1 to Pier 7. Hard rock strata never found and only black coal strata in encounter. Since black coal does not match the property of hard rock, the sinking of well has to be done as per the approved design. You had never requested in writing to railway to review of the design. Although during the meeting held at Bilaspur on 29/8/2013, the issue was discussed and it has been advised to you for conducting fresh soil investigation and submit revised design, which has not yet done. The sinking of well is time-tested method in bridge engineering, particularly in railway. Hence, reason explained by you is not acceptable. Then, my lord, the last, further two option has been suggested by you, again which remarks are given. You have been already advised during meeting on 29/8/13 to do fresh soil investigation and submit revised design, but no design submitted till date. Also, rate of well sinking include all types of strata in the existing schedule. Hence, non-schedule items cannot be operated. For poor progress of the work, you have entirely responsible. Therefore, termination notice wide 5/3/14 with forfeiture of security deposit encashment is given. So, my lord, here, my lord, this letter is the reply of that, for closing of the contract. So, my lord,
So the main issue with regard to the exhibit NN and exhibit 14 and exhibit S.
my lord,
These are the two documents.
yes,
They have terminated. They have foreclosed. They have closed the contract.
yes,
and you have not given the claim what he has made. And you stated that it will all the security deposits shall be forfeited.
my lord, here it has been, my lord, that under the, my lord, that the contract, my lord, the termination is without any risk. That is there, my lord. So, my lord, but in my counterclaim, whatever the loss, my lord, incurred, which, my lord, that detail has been given in my counterclaim. That I will come before lordship. Then, my lord, I will place before lordship that the by letter dated this I have said the plaintiff, my lord, the plaintiff in their letter dated 20th December 2011 has alleged non-availability of Ultratech cement and consequent adverse impact of delay in completion of the project.
What is the date?
That is the 20th of December 2011. The plaintiffs alleging this, my lord, and the defendant railway submits the plaintiff cannot take the plea of non-availability of Ultratech cement in view of the provisions contained in chapter 5, that is the certificate of familiarization being part of the contract agreement, exhibit D. Kindly exhibit D it has in and chapter 5.
Yes.
This is chapter 5, my lord, part of the contract, and this is the certificate of familiarization, and this is binding on the parties. And what the, my lord, it is stated here, my lord, that I hereby solemnly declare
Chapter
that
5.
Chapter 5, my lord, chapter 5 of the contract.
Yes.
Actually, you got it.
Familiarization.
Yes, my lord. Certificate of familiarization.
Yes.
My lord, here, my lord, here this certificate is given by the plaintiff's contractor.
Yes.
What the plaintiff saying, I hereby solemnly declare that I have visited the site of the above work and have familiarized ourselves of working conditions there in all respect and in particular of the following. And what are the following, my lord? The area and the constraint therein. Whether it's a hard rock or hard coal, that is the familiarization. My lord, then, my lord, the availability of service approach passage. He has to carry out the work, he has to see. Then, my lord, soil condition at this site of work. My lord, sources and availability of good earth blanketing materials and other construction material, whether it's ultra-tech cement or whether it is the other construction materials, whatever the required for the construction of the bridge, those whether available and how will be available, that is the outlook of the contractor. After this declaration, that cannot take the plea. Rates and availability of the construction material. Availability of the local labor, skilled, unskilled, and prevailing labor rates. Availability of water and electricity. Availability of space of putting of labor camps, office, store, goods, and engineering yards, etc. Likely site constraint in collecting material, working contract, etc. Existing road network, highway, or other types, availability of service road. Source and availability of construction materials. Sources and availability of construction material. So cement is the construction material. So this is being the certificate of familiarization, and after that, if a declaration is made, can a plea be taken that the ultra-tech cement was not available, and that is the reason that this execution could not be done. Now I come to issue 5. Whether it was the plaintiffs who were
No, close. Your argument closed now. Time is over. You're not completed in with 45 minutes.
Today I started with 15 minutes late today.
So suffering for the plaintiff. So suffering for the defendant. Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Date fix है क्या?
No, no further date.
Let the matter appear on. Come after vacation. How much time you will take, Mr. Julian? Now you are in trouble.
I
studied said, I took
vacation, then I can start afresh.
Study when your lordship inquired, that how much time will take? I will take, I said 1 hour, and today I took half an hour, So half an hour still I have, So
half an hour left.
कोई date नहीं है ना? किसी time
it can be fixed in May,
May में कोई नहीं, इनका खत्म करवा देगा.
Or it can be kept high up in the list. It's a commercial matter. It can be called because he is also here. I am also here.
I have no problem. This is the convenience of my lord.
If it is kept high up,
it's better if it is specially fixed, so there will be no crowd.
Specific, there is no time. There is no date here. Before vacation, there is no date here.
In May, any time May, 1 hour can be fixed.
7-8 कोई सब fix है. P45 है कोई? P45. तो है. अच्छा थर्सडे है ना? कितना बजे? 3 बजे मैटर है. फिर वो कहाँ अपील हुई, वो क्या नाम अपीलेट सेट का कोई क्या मैटर है? फर्स्ट अपील का वही हो जाएगा, टाइम नहीं मिलेगा. Seventh May at the top. Seventh May
at the top.
No time. At the top.
At the top. 10:30.
Let us see. Mentioning and all these things will come. Then it will be taken.
Good.
Let it appear after to be mentioned, Milan. Let it appear then after Milan to after to be mentioned. Milan, mention that Milan. Otherwise, Milan again Milan due to passage of time.
What?
What them? Take it. Very good. Take it. Good. Good.
Item number 6, 345.
Let me give you a lordship, son.
Yes.
Dear Lord, hearing the matter with regard to the reputation of the insurance policy.
Yes.
Your Lordship will remember that the policy was repudiated on the ground. It was not because of my lord shutdown of the refrigeration for my lord more than 24 hours, but because of ammonia leakage.
Correct.
I had my lord shown your Lordship the provision. Now, my lord, we are trying to interpret this contract. I had shown your Lordship the basic facts. I do not wish to go back on that. My lord, now the question is, how does the contract, my lord, have to be interpreted? My lord, this, my lord, has to ultimately draw its, my lord, inspiration from, my lord, the law that required, my lord, the insurance policy to be taken out in the first instance. My lord, I am a cold storage owner. Now, my lord, I am mandatorily required to insure, my lord, the produce of the cold storage, the goods stored in the cold storage. My lord, that your Lordship will find from the provisions of the West Bengal Cold Storage Act, which I've asked my colleague to, my lord, to carry for your Lordship. Let's have a look at the Cold Storage Act. Just one section. Well, this is called the West Bengal Cold Storage Licensing and Regulation Act 1966. Please come to section 15. Well, just section 15.
Yes.
It says cold storage building, cold storage machinery, and the agricultural produce stored in a cold storage shall be insured against such items of risks and with such insurance company or companies as may be determined by the licensing officer from time to time, provided that pro rata premium in respect of the agricultural produce only shall be paid by the hirer in such manner as may be prescribed. Now, there are three things here. One is, my lord, there is mandatory, my lord, requirement of insuring three things.
Yes.
One is the cold storage building, one is the cold storage machinery, and third is agricultural produce.
Yes.
Second is, my lord, it shall be insured, my lord, with such insurance company as may be determined by the licensing officer. So I don't have a choice of the insurance company also. And third thing is that, my lord, the hirer, that is, my lord, the person who puts in his cold storage produce in the cold storage, shall pay pro rata premium in respect of the agricultural produce. Now, all these three things are therefore, my lord, statutorily mandated. Now, if your lordship will now have a look at, my lord, the minutes of one of the meetings, my lord, of 23rd March 2022, of, my lord, the Director of Agricultural Marketing, that your lordship will find at, my lord, page 42 of the plaint.
Yes.
Well, this is a proceedings of a meeting held on 23rd March 2022 and 29th March 2022 in the chamber of the Director of Agricultural Marketing. Please see what it provides. The Director of Agricultural Marketing West Bengal took the chair and welcomed all participants. At the outset, discussion started with clarification of rate for DOS and FOS policies of 4 nationalized insurance companies. So 4 companies were identified for insuring these products. After discussion, the House reached a consensus towards calculation of rate of premium on DOS policy for 10 months and FOS policy for 12 months at 0.708 and 0.2065 per rupees 100 respectively, which has been derived in the following manner. Now, I am not trouble you lot with that. Then, after the table, after reaching the consensus, the Director of Agricultural Marketing placed the prevailing wholesale price situation of potato in the state during the loading season of 2022. This year, a huge variation in potato price has been observed throughout the state. So, the lowest price prevailed in the state during this loading season has been considered for covering insurance. The House reached at a consensus that maximum pro rata charge would be calculated at rupees 1370, that is rupees 1200 per quintal prevailing wholesale price of potato plus 170 per quintal average cold storage rent. The maximum pro rata charge to be realized from the hirers shall be 12.50 per quintal as per the following calculation. So, my lord, what is fixed is, my lord, the storage charge and, my lord, the rental charge, the total, my lord, insurance value. Then your lordship will kindly have a look at the next document, my lord, which is at page 41. My lord, this is 29th March 2023.
Yes.
2022, I'm sorry. Again from the Director of Agriculture Marketing. In exercise of the power conferred upon the licensing officer under Section 19 of the West Bengal Cold Storage Licensing and Regulation Act and Rule 4Q of the West Bengal Cold Storage Licensing and Regulation Rules, and consequence upon the decision taken in the meeting held on 23rd March 2022 and 29th March 2022 regarding fixation of price of potato for insurance coverage. All the licensees of the potato cold storages of West Bengal are hereby instructed to cover DOS and FOS policies at the price of rupees 1370 per quintal of potato during the year 2022. In this respect, rate of calculation of premium of DOS and FOS policy would be 0.70 and 0.2065 per 100 respectively. Maximum pro rata charge allowable for realization from hirers will be 12 rupees 50 paise per quintal. So, my lord, all this is fixed. So, my lord, I am supposed to, my lord, take out this policy. Why? Because, my lord, in case the produce that is stored in the cold storage by the hirers goes bad, my lord, the poor farmers are not left at my mercy. The poor farmers can be compensated. That is the logic, that is the, my lord, philosophy behind these policies.
Correct.
Now, my lord, I am supposed to ensure what? My lord, 1 is the cold storage building, 2 the cold storage machinery, and 3 the produce. 3 things for which insurance companies are identified, and, my lord, premium is identified. How much I can get from the hirers is also identified.
Correct.
Now, in this context, your lordship would now kindly consider as to whether, my lord, the interpretation that is being sought to be given by, my lord, the insurance company can be accepted. Now, if your lordship will kindly come back to the DOS policy once, at page 121 of the plaint, my lord, this is, my lord, really the bone of contention.
Yes. This all are exhibited?
Yes, my lord, all of it's exhibited. Well, in fact, my lord, I think this is also there as a part of the judge's brief. My lord,
Okay, no problem. No problem. You continue with this. We'll see.
Yes, my lord. Now, my lord, this is, my lord, really the bone of contention.
Yes.
I shall show you, lordship, from the reputation once again. Well, just one paragraph. Now, this policy of insurance witnesseth that in consideration of the insured having paid to the company the premium mentioned in the said schedule, the company hereby agrees with the insured, subject always to the terms, provisions, warranties, and conditions contained herein, or endorsed hereon, that if at any time during the period of insurance stated in the schedule, or during any subsequent period for which the insured pays and the company may accept the premium for renewal of this policy, there shall occur an accident as hereinafter defined. 2. The refrigeration machinery described in Schedule 1, resulting in a rise in temperature in the refrigeration chambers, thereby directly causing damage to the goods described in Schedule 2 by deterioration, putrefaction, or contamination. Following such accident, then the company will, subject to the terms, exceptions, warranties, and conditions contained herein, or endorsed or otherwise expressed herein, indemnify the insured for such damage. Now, I'm pausing here for a moment. They are saying that this will ultimately have to be damage resulting from failure of the refrigeration for more than 24 hours, which leads to one of the 3 things: deterioration, putrefaction, or contamination. Now, as I had submitted before your lordship earlier, if today the refrigeration machinery breaks down, then there can be deterioration, there can be putrefaction. But contamination cannot happen. In this case, what had happened is ammonia had leaked.
Correct.
That ultimately affected the entire quantum of potatoes stored in the chamber number 3 of the cold storage. Now the question is, what then would be the meaning that can be ascribed to the word contamination? Can the insurance company simply walk away saying that no, it is not because the refrigeration equipment had failed? Now, my lord, in this context, my lord, may I straight away take your lordship to a few judgments, my lord, which clearly discusses how these exclusion clauses are to be read or understood. Well, the first judgment that I would like to rely on in this regard is the judgment in the case of Scandia Insurance. This is reported in 1987, Volume 2, Supreme Court Cases 654.
1987?
Volume 2, Supreme Court Cases 654.
Yes.
Now, my lord, please have a look at, my lord, the facts of the case, paragraph 2.
My lord, copy is missing from the bunch. That report is missing from my.
Not there.
It's missing from my bunch, my lord.
Your colleagues have
No,
not.
don't waste the court's time. My lord, may I show your lordship the next judgment? My lord, I hope, my lord, my learned friends are carrying at least this one. This is B.V. Nagaraju.
Yes, yes.
My lord, this is reported in 1996, Volume 4, Supreme Court Cases, page 647.
Yes.
My lord, please have a look at paragraph 2. My lord, how the court is interpreting these clauses. The appellant herein was registered owner of a Tata truck bearing number such and such, duly insured with the Oriental Insurance Company Limited, the respondent herein with a policy number such and such. The policy was comprehensive in nature, covering risk to the limit of rupees 2,09,000. During the subsistence of the policy, the vehicle of the appellant met with an accident on such and such, when allegedly a gas tanker came and dashed against the said vehicle. Apart from the other damage which occasioned due to the accident, the appellant's vehicle sustained major damages on account of which repairs was necessitated. The appellant therefore incurred costs. Then, my lord, paragraph 3. The respondent company denied their liability altogether, stating that since the appellant's goods vehicle was used for the purpose of carrying passengers, the appellant was disentitled to claim any compensation, and even otherwise, those were 9 in number. The amount of money spent by the appellant on repairs was, however, not seriously disputed. Then paragraph 4. The State Commission went into the matter thoroughly and by its order dated such and such allowed the claim of the appellant to the extent of 75,700. Now, this was thereafter upset in appeal. Well, your lordship will find from the last 4 lines of this paragraph, the order at the instance of the respondent company was, however, upset on appeal on such and such by the National Consumer Disputes Redressal Commission, relying upon the terms of the insurance policy in taking the view that the policy did not cover use for carrying passengers in the vehicles except employees other than the driver, not exceeding 6 in number. So, this was their defense, that you did not abide by the policy terms.
Correct.
Paragraph 5. The terms of the insurance policy interiorly provide as follows. Limitations as to use. Only for carriage of goods within the meaning of the Motor Vehicles Act. Then, next policy, the policy does not cover used for organized racing, pacemaking, reliability trial, or speed testing, used while drawing a trailer except towing for any disabled mechanically propelled vehicle, used for carrying passengers in vehicle except employees other than driver not exceeding 6 in number, coming under the purview of the Workmen's Compensation Act. Counsel for the appellant in support of this appeal strongly relied on Scandia case. Well, this is judgment I wanted to show you, lordship, first. Making a fervent appeal that the terms of the policy afore referred to should be read down to carry out the main purpose of the policy. This is very important, to carry out the main purpose of the policy, as the presence of 9 persons, when up to 6 were permissible, irrespective of their being employees or not, had not contributed in any manner to the occurring of the accident, as also when the claim did not relate to any injuries to those 9 persons who were owners of the goods loaded, or any loss occurred by them. The claim pristinely relating to the damage caused to the vehicle insured, which could not have been denied in the facts and circumstances, strong reliance in support was sought to be placed from the reasoning of State Commission, which had, in so many words, said, even for the sake of argument that 9 persons traveling in the vehicle were passengers, it cannot be a ground for the insurance company to repudiate the contract as the fact of their being passengers or coolies does not make any difference to the risk involved. These persons were in no way concerned with the cause of the accident, nor have they contributed to the risk in respect of the loss caused to the vehicle. The complainant has not claimed any compensation in respect of the liability to the persons traveling the vehicle. It is plain from the terms of the insurance policy that the insured vehicle was entitled to carry 6 workmen, excluding the driver. If those 6 workmen, when traveling the vehicle, are assumed not to have increased any risk from the point of view of the insurance company on occurring of an accident, how could those added persons be said to have contributed to the causing of it is the poser, keeping apart the load it was carrying? Here it is nobody's case that the driver of the insured vehicle was responsible for the accident. In fact, it was not disputed that the oncoming vehicle had collided head-on against the insured vehicle, which resulted in the damage. Merely by lifting a person or 2 or even 3 by the driver or the cleaner of the vehicle, without the knowledge of the owner, cannot be said to be such a fundamental breach that the owner should, in all events, be denied indemnification. The misuse of the vehicle was somewhat irregular though, but not so fundamental in nature so as to put an end to the contract, unless some factors existed which by themselves had gone to contribute to the causing of the accident. In the instant case, however, we find no such contributory factor. In Scandia case, the court paved the way towards reading down the contractual clause by observing as follows. When the option is between opting for a view which will relieve the distress and misery of the victims of accidents or their dependents on the one hand, and the equally plausible view which will reduce the profitability of the insurer in regard to the occupational hazard undertaken by him by way of business activity, there is hardly any choice. The court cannot but opt for the former view. Even if one were to make a strictly doctrinaire approach, the very same conclusion would emerge in obeisance to the doctrine of reading down the exclusion clause in the light of the main purpose of the provision, so that the exclusion clause does not cross swords with the main purpose highlighted earlier. The effort must be to harmonize the two instead of allowing the exclusion clause to snipe successfully at the main purpose. The theory which needs no support is supported by Carter's breach of contract, to quote, notwithstanding the general ability of contracting parties to agree to excluding clauses which operate to define obligations, there exists a rule usually referred to as the main purpose rule, which may limit the application of wide exclusion clauses defining a promisor's contractual obligations. For example, in Glynn versus Margetson and Company, Lord Halsbury had stated, it seems to me that in construing this document, which is the contract of carriage between the parties, one must in the first instance look at the whole instrument and not at one part of it only. Looking at the whole instrument and seeing what one must regard as its main purpose, one must reject words, indeed whole provisions, if they are inconsistent with what one assumes to be the main purpose of the contract. Well, these are very important words. Although this rule played a role in the development of the doctrine of fundamental breach, the continued validity of the rule was acknowledged when the doctrine was rejected by the House of Lords in Swiss Atlantic Society, such and such. Accordingly, wide exclusion clauses will be read down to the extent to which they are inconsistent with the main purpose or the object of the contract. The National Commission went for the strict construction of the exclusion clause. The reasoning that the extra passengers being carried in the goods vehicle could not have contributed in any manner to the occurring of the accident was barely noticed and rejected sans any plausible account, even when the claim confining the damage to the vehicle only was limited in nature. We thus are of the view that in accord with the Scandia case, the aforesaid exclusion term of the insurance policy must be read down so as to serve the main purpose of the policy, that is to indemnify the damage caused to the vehicle, which we hereby do. Well, just pausing here for a moment. Well, the main purpose of the insurance policy to protect the farmers from the losses. Well, it was a statutory requirement which obliged the insured to take out the policy against payment of fixed premium from designated insurance companies. Now, today, your Lordship has seen the 3 expressions used in the exclusion clause is deterioration, putrefaction, contamination. Now, the doctrine of reading deeds and documents is to give every word a meaning. You cannot treat any part or portion of any word as a surplusage. So if one has to give any meaning to the word contamination, then contamination is not something that can result from raising of the temperature of the chamber of the cold storage. And hence, my lord, ammonia, which was the cause of, my lord, the damage here, leaking ammonia, must be covered. Second is, my lord, the main purpose. So this is, my lord, approaching the matter from the, my lord, perspective of, my lord, no clause shall be treated to be a surplusage. Secondly, my lord, so far as this is concerned, the matter is, my lord, that the main purpose is to protect the farmers. The main purpose is to protect the persons who will come and deposit their produce in the cold storage. So, my lord, you cannot today try to interpret the contract in a manner which will defeat the main purpose. And a exclusion clause cannot be so widely or broadly worded which will defeat the main purpose. So, to that extent, if necessary, because I don't say that this requires any reading down, if necessary, your lordship will read down the contract so that the main purpose is not allowed to be frustrated. Well, the next judgment that I'd like to cite in this regard, I'm again hoping that my learned friends are carrying this. Well, it is reported in 2023, one Supreme Court cases 428. Well, this is a very recent judgment. They also 2023, one Supreme Court cases 428.
Yes.
Does your lordship have a copy? I
got.
Yes. We're very fortunate.
Prince is also coming, my lord. Printout is coming.
Well, please have a look at paragraph 2. The appellant secured a standard fire and special perils policy from the respondent. The policy was effective from such and such. It was meant to cover a shop situated in the basement of the building. However, the exclusion clause of the contract specifies that it does not cover the basement. Due inspection of the shop was made, which was actually situated on the other side of the road from the office of the respondent number 1. Not only this shop of the appellant, but yet another shop similarly situated was also insured by the respondent number 1. The appellant continued to pay the premium promptly. Then your lordship will skip over some of the paragraphs. Well, this was again, ultimately sought to be repudiated on the basis of the exclusion clause. Please come to paragraph 12. An exclusion clause in a contract of insurance has to be interpreted differently. Not only the owners, but also the burden lies with the insurer when reliance is made on such a clause. This is for the reason that the insurance contracts are special contracts premised on the notion of good faith. It is not a leverage or a safeguard for the insurer, but it is meant to be pressed into service on a contingency, being a contract of speculation. An insurance contract by its very nature mandates disclosure of all material facts by both the parties. An exclusion clause has to be understood on the touchstone of the doctrine of reading down in the light of the underlying object of the intendment of the contract. It can never be understood to mean to be in conflict with the main purpose for which the contract is entered. A party who relies upon it shall not be the one who committed an act of fraud, coercion, or misrepresentation, particularly when the contract along with the exclusion clause is introduced by it. Such a clause has to be understood on the prism of the main contract. The main contract, once signed, would eclipse the offending exclusion clause when it would be otherwise impossible to execute it. A clause or a term is a limb which has got no existence outside. As such, it exists and vanishes along with the contract, having no independent life of its own. It has got no ability to destroy its own creator, that is the main contract. When it is destructive to the main contract, right at its inception, it has to be severed, being a conscious exclusion, though brought either inadvertently or consciously by the party who introduced it. The doctrine of waiver, excusance, approbate, and reprobate, and estoppel will certainly come into operation. Then, on the aforesaid principle of law, particularly with regard to the issue of qua, onus, burden, and reading down, the court in Shivaram Chandra Jagannath Cold Storage, this is what it held. It quotes from the B.V. Nagaraju judgment that I have just placed before your lordship, so I will not trouble your lordship with that. Then it goes on to discuss the other facets of exclusion clauses, and finally holds that it has to ultimately subserve the purpose of the main contract. If your lordship sees, paragraph 14 of B.V. Nagaraju has been reproduced.
Yes.
And my lord, I don't want to trouble your lordship. I've already placed this. So my lord, what is very important is that my lord, ultimately one has to understand the main purpose of the contract. You cannot read an exclusion clause to destroy the main contract itself. And if necessary, you have to therefore read it down. Well, the last judgment that I'd like to cite in this regard is also something that my lord is impossible to ultimately contain. Well, the last judgment is a 2025 judgment. Well, this is reported in 2025 SCC Online SC 746.
2025?
SCC Online SC 746.
Well, this is also coming. It's on the way, my lord.
Well, I don't want to, my lord, waste your lordship's time. The essential proposition, my lord, is this too. My lord, this is also echoed in the Scandia judgments, my lord, which I shall just give your lordship, my lord, the citation for. Well, I shall just hand it up to your lordship so that I do not, my lord, unnecessarily hold your lordships up. Well, the Scandia judgment is reported in 1987, two Supreme Court cases, 654.
Yes.
And well, the 2025 judgment citation I've given your lordship. Well, what the 2025 judgment held is that there's a clause in the insurance contract which says that the vessel will not be covered for risk if it plies during the monsoon. But it was very apparent that the vessel was intended to ply on the monsoon itself. So the Supreme Court held that when today you know what is the main purpose of the contract and you put a clause that is going to militate against the main purpose of the contract, you cannot rely on that clause. I shall hand up these copies of the judgments, but this is essentially the substance of it. So, based on this, my very respectful submission to your lordship is that the repudiation of the contract is wrongful. Now, once the repudiation of the contract is wrongful, then, we come to the claims. Now, the first claim is on account of the claim of the produce. Your lordship has seen that, what would be the value of the produce has been quantified and, ultimately paid down. Now, if your lordship will kindly have a look at what, the prayers in the claims are. The claims made are, please come to the plaint at paragraph 58.
Yes. Yes.
Now, the first claim your lordship will see is for only a sum of 6,103
that is
on account of insurance breakdown. Now, so far as this is concerned, your lordship might remember that they had initially, done a survey. There's a report. They gave us a discharge voucher. We filled up the discharge voucher, submitted it, but they did not act on it, obviously because if they accept the fact that there's breakdown of machinery and give us compensation, because only a valve had gone bad. So only that's why 6,000 rupees. Then they have to accept the rest of the claim. So ultimately, even after accepting that this is the loss suffered, giving us a discharge voucher, accepting back the discharge voucher from us duly signed, they did not proceed any further and they repudiated that claim also. I've shown you, lordship, the letter of repudiation. And that is where it stands. So this is the first claim on account of only 6,103 for breakdown of machinery for which discharge voucher was given, filled up, submitted. Then the next claim is on account of stock deterioration. Now your lordship will find that the surveyor has himself accepted the fact that the total value of the stock that got destroyed was 7,92,29,155.
Yes.
Now, so far as this is concerned, again, the destruction of the value is accepted, but the claim is repudiated on the ground that this was caused due to leakage of ammonia. Then the third claim is for interest on the sum of rupees 7,92,00,000. Now, this damage occurred in October 2022, but was not paid. Now, the consequences have been grievous. Apart from the fact that we could not get the money, what happened is, we could not, we have to get them at cold storage, emptied. Whenever there's damaged stock, it has to be immediately removed. Now, we could remove only a part of the stock. We could not remove the rest of the stock because, we were gear out. We could not pay, the farmers. There was mass agitation. Our proprietors or partners were beaten up. There were police complaints lodged against them. Their accounts with the banks became NPA. All consequential cascading effects of non-payment of the insurance policy followed. But my lord, apart from the fact that here, my lord, what we have claimed, kindly see interest at the rate of 12% on the principal claim. Why? My lord, because it was a result of a commercial borrowing from banks. I have given all the documents. I shall show you, lordship, on the documents. So, my lord, that is why interest on this is claimed at 12%. Then your lordship will find that, my lord, there are expenses that have been incurred on account of, my lord, disposal of contaminated potatoes. Now, my lord, this up to a point has been allowed. Well, that is the point of time when the survey took place. Because we could not remove the rest of the stock thereafter, my lord, for a long period of time because of gheraos and, my lord, other agitation. My lord, we have calculated it at the actual rates, which, my lord, on which the stock was removed. My lord, that is all on record. I shall give you, lordship, the document numbers, so it's easier for your lordship.
Yes.
Then, my lord, finally, if your lordship sees, my lord, there's, my lord, I must submit, my lord, with some degree of, my lord, concern as to how this claim has been formulated. Claim number 4, compensation due to loss of business opportunities as pleaded in paragraph such and such.
Yes.
Now, my lord, here I must tell your lordship that, my lord, what has been said is that, my lord, this is the total quantum of, my lord, potato that we could have stored during the season. We could not store this potato because, my lord, you did not compensate us. I could not pay the farmers. I could not, my lord, ultimately get them to, my lord, give me further potato. All the justification is there. But, my lord, how we have calculated this claim is, my lord, something that ultimately, my lord, I must bring to your lordship's notice. My lord, I have calculated this is a total value of the stock that I could have taken in, and this is the total, my lord, revenue that I could have earned. But, my lord, my loss is not the loss of revenue. My loss is the loss of profit. Because, my lord, there are expenses when I get in potato. My lord, there are expenses that I have to incur, my lord, for refrigeration, cold storage, labor, and other things. So, my lord, the entire revenue loss is not my loss. The loss is the loss of profit. My lord, that, my lord, so far as it's concerned, my lord, has not been clearly quantified here.
Okay.
Your lordship will, my lord, consider the Supreme Court judgments on the matter, which says that normally loss will be between 10 to 15%.
Yes.
I have to tone down, my lord, that claim because I cannot justify the claim that I have made. With all honesty, my lord, the rest are, my lord, small claims, repairing of chambers of, my lord, the cold storage, and, my lord, for interest that I had to pay bank, my lord, this is all on record. My lord, because I could not service the bank's debt, the bank kept charging interest, my lord, for which I have claimed, because this is a direct loss. It is not an indirect or remote loss.
Yes.
My lord, these are the losses. My lord, I will, since I've showed you, lordship, the law, I shall now have to satisfy lordship that I'm entitled to these claims. My lord, this is an undefended suit. My lord, there is no, my lord, defense taken to this. My lord, it's 4:20 now. My lord, I finished with the law part of it. My lord, I shall just have to satisfy lordship on the quantification of the claims. And I
Yes.
shall give you lordship reference to the documents instead of taking your lordship to the documents in themselves, so that I can, my lord, quickly finish the matter.
Okay. Thank you.
My lord, whenever it's convenient for your lordship, next, my lord.
Well, those two judgments have been handed up, my lord. Scandia Insurance and Shoham.
Okay. Okay. Record and not. Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on when? Data.
Well, whenever your lordship has the time. I don't know. It's very difficult.
3:45 I think it is.
1 तारीख को क्या है कुछ है 11:30 में नहीं है फिक्स है 6 में बाकी उससे पहले 11:30 सब है ही क्या तो मैं में 7 6 में at 11:30
Yes, man. I'm grateful.
Hello. Grateful.
With your lordship's leave, may I be permitted to mention a matter? My lord, this is my contempt application. The interim order is expiring today, my lord.
I appear for the alleged contempt. The contempt petition was not made returnable, I'm told. It could appear any day.
When returnable date?
It was taken up a few weeks
When is the
back.
returnable
It was taken up on 11th April, my lord. No returnable date has been fixed, my lord. I've handed over the copy of
The
Only
order does
interim order extended.
only the interim order was extended,
there
my
is no
lord.
return. It was argued.
Notice issued.
Notice, notice.
It was argued finally. Mr.
Finally,
Yes, but it was being argued. But
affidavits completed.
yes,
Yes,
affidavit
lordship.
complete was finally argued. But she may
So
keep the
I am
matter
fixing in the month of June.
Lordship.
any different.
Sensation suffering for the petition, sensation suffering for the alleged contempt. Counsel for the petition submit that the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 12th June 2025 or until further order, whichever is earlier. Let the CC80 of 2024 be placed before this court on 12th of June 2025.
Grateful, my lord.
But may I have your lordship's leave to mention item 12 of your lordship's list, which was taken up today. Lordship has adjourned the matter, kept the matter on 29th. But the interim order is there till 25th. I forgot to mention that. I'm mentioning upon notice. If it could be.
I'm appearing for the defendant.
The
Any objection for
No,
action?
no, I don't have any objection.
Sure.
Yes.
Then your senior will come that no instruction was given.
No, no.
13 June. 13 June.
13 June.
Contempt application 13 June.
No, item 12. Yes, well, the contempt application may appear on 13 June. The interim in item 12, the last interim order was extended till 25th. And the lordship has kept the matter on 29th.
29th of April.
29th of April. For hearing of all the three applications, addition of party, section 8, and judgment on admission.
Flint Group, that one.
That one. I forgot to mention that the interim order is expiring.
Suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff submission.
But lordship has already passed an order. But
order already किया है, उसमें interim order is extended till 29th.
I'm grateful.
Only order. याद से मैं तो मुश्किल हो जाएगा. याद से बता देना.
Yes. May I have leave to mention this matter? This is a suit for eviction. And there are two applications pending. Lordship had heard this matter extensively, but because of the change of determination, this was assigned before Justice Arindam Mukherjee. Justice Mukherjee had heard this matter today and he has released this matter. But the only difficulty is that our interim order is till 25th of this month. And there is order of release. We requested Justice.
At the time of release, why you are not prayed for the extension?
Lordship, I'm coming over there. Today only matter was taken up. We had prayed for extension. But Lordship indicated that it will not be extended. He did one favor to us, that the order was uploaded today only. It was passed today in the morning and it is uploaded today.
How this court will take? Release, then you have to take the...
Your Lordship had heard this application. There was an application.
The part heard?
Yes, Your Lordship. Your Lordship had heard the defendant and defendant had concluded. Plaintiff had started submissions. That was pending, Your Lordship.
It was recorded as part heard?
Your Lordship, it has not been recorded as part heard. It has been recorded that counsel for the defendant.
Lordship, we had also written a letter to the registrar for getting it assigned. The order of assignment will be passed by lately tomorrow. We requested that it should be expedited.
So when the interim order is going to expire?
25th.
25th. Today we are on?
22nd.
Come on 25th. If it is assigned, it's okay. If not assigned, also you mention it.
Lordship, if it's not there in that day list, then a supplementary list has to be taken out. That is the only difficulty.
You do one thing, you mention on 24th if it is not assigned.
Much obliged.
If it is assigned, you will be listed. If it is not assigned, you mention on 24th.
Much obliged.
not to wait on 25th.
Okay, much obliged.
That Ravi Sanai matter, your lordship has been kind enough to extend the interim order. But your lordship has fixed it on 12th June instead of 12th June any other day.
But my instruction, well, the contempt application where your lordship has extended the interim order. But would it be? But could it be before the vacation any day?
Vacation, no problem.
Before the vacation.
Before vacation.
Mr. Mitra was on the verge of concluding his submissions.
No. That's why I find that all the matter is fixed to 11:30. I don't know how the judgment will be delivered.
We'll come back on
13 June come, then we'll sit. Come on 13 June.
Will come.
Lordship, regarding the item number 1 today, Your Lordship, I tender my apologies. I should not have interrupted Your Lordship when Your Lordship was dictating the order. Kindly.
तुम dictation दिया था.
Lordship, it was just for correction of an order.
ऐसे आ जाओ, फाइल लेके आ जाओ.
My apology, Your Lordship.
फाइल लेके आ जाओ.
Grateful.
ना फाइल लेके आ जाओ.
Grateful.